order of the LRTT without original certified copy. I have applied.
My lord, for inclusion in the list.
What?
My lordship, first appeal 183 of 2025.
No.
My lordship,
Can you can mention, but not hearing. Hearing, ma'am, we are not now taking. We took some matters last week, but
Application is pending.
wait for some time. Wait for some time.
Application.
Let's maybe not for inclusion, my lord.
Application, yes.
My lord, for inclusion application.
An application, Millards.
Application, yes.
Application in the first appeal, Millards.
Well, application.
Why have we written hearing?
WPLRT hearing, my lord. Not possible. WPLRT. 2023.
Hearing is not possible.
Yes.
Blood application.
Yes.
Application.
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 My lord, hearing won't be taken up now.
No.
Great. sir.
Next. Call on the list. এটা কি জন্য তুমি বলছো? আচ্ছা ওরাই করে মেনশন।
My lord, I'm for the appellant in
Why
this
is it
matter.
appearance to be mentioned?
Yes, my lord, in this matter, direction was on us to pay the postal cost within a fortnight from date, but inadvertently we didn't pay it within a fortnight and we paid on 24/8.
Beyond a fortnight.
Yes, my lord. So for this reason, liberty be given to accept the such postal cost.
Yes, sir.
My lord, I appear for the respondents. First, my lord, paper book directions were there. Once
Yes,
that is done, my lord, it's ready for hearing. There's an interim order in their favor already. my lord.
On the prayer of learned counsel for the appellant, the delay in depositing postal costs and requisites is condoned, and the said postal costs are accepted, which of the office shall take step accordingly as per previous directions. Next.
Plus.
2, yes. What are you doing? What are you doing?
Sir, ma'am को देना.
You ma'am ko de rahe.
Application, sir. Mentioning.
You are calling the list, ma'am. Learn some decorum before you come to court. Yes. Yes, item 2 who is appearing.
I'm appealing for the respondent. My lord, on the last occasion, I've commenced my argument. The appellants have finished their argument. My lord,
Yes, you remember.
my lord, I was arguing. My lord, this issue was, my lord, just recapitulating. My lord, the entire argument of the appellant.
Oral agreement.
Oral agreement.
Yes.
Now, my lord, my argument.
Stamp is apparently a background. Anyway, you argue if you want.
Now, my lord, not on stamp. My lord, prima facie, I was showing.
Yes.
My lord, that since this is a case, my lord, based on an oral agreement.
Yes.
Now, my lord, the law, my lord, is settled on the issue is, my lord, that the oral agreement, the court has to visualize, my lord, there was an oral agreement. My lord, unless that strongest case is being made out, my lord, the court will not be inclined to grant any form of injunction. Now, my lord, to show this, my lord, I was referring, my lord, to taking my lord to the plaint. Now, my lord, kindly takes up the plaint for once.
Which page?
My lord, volume 1.
Yes, yes.
My lord, I was referring to paragraph 4.
Which page?
Page 11, volume 1.
11 page, para 4 starts.
Para
yes.
4 starts.
Yes.
Now, my lord, I was placing it. Now, my lord, kindly may I just place once again for sake of continuity. The defendant number 5, a company within the meaning of Companies Act 2013 and dealing in the property broking and or trading, entered into an agreement with the pro forma defendant number 6 to 32 to purchase their respective land, both divided and undivided shares. Thereafter, by 3 several agreements, all dated 25th February 2013, Suraj Kantopal, my lord, other Pals, Pal family, my lord, being the pro forma respondent number 9 to 9, 10, up to 8, respectively entered into agreements for sale with the plaintiffs herein, whereby the pro forma defendant number 5 assigned and or nominated the plaintiff in its place and state for purchase of plots of land. The pro forma defendant number 5 was the confirming party to the said agreements. The said assignment under nomination did not include the holding of defendant number 1. It transferred from the records that the defendant number 1 was holding substantial land in the said total area of 23.89 acres. Since the plaintiff wanted to acquire the entire area of the land for the purpose of setting up an industrial park, the plaintiff approached the defendant number 1, requesting him to also transfer his holding in the said area, scattered in various plots. Various negotiations took place between the defendant number 1 and the representative of the plaintiff starting from the month of April 2013, and ultimately an oral agreement was entered into between the parties on or about 7th of May 2013 to the following effect. The defendant number 1 owns total 3.80 acres of land, which is held in an undivided share as well as divided share. That the defendant number 1 shall convey the total area of 3.8680 acres of land to the plaintiff at an agreed consideration of 6 crore 88 lakhs 22,217. That the partitioned area of 151 decimals of land, which is held by the defendant number 1 as exclusive area in various plots in Mouja, Biponnopara, jail number 27, shall be conveyed by the defendant number 1 in favor of the plaintiff upon the plaintiff performing the reciprocal obligations. This is important. This 151 is the suit property. The plaintiff would convey to the defendant number 1 65,640 decimals of land in several plots within Mouja, Biponnopara, jail 27, PS Domjur district, Howrah, which the defendant number 1 shall be entitled to hold as exclusive area, and for which the defendant number 1 would pay to the landlord a sum of rupees 1 crore 24 lakhs as consideration for such transfer. Upon transfer of said 64.64 decimals of land, the said defendant number 1 would convey and transfer 65.640 decimals of land in several plots, both in Mouja, Mohiyari, totaling 53.99 decimals, demarcated along with undivided 1/7 share in different areas at Mouja, Biponnopara, and Mouja, Mohiyari, totaling 11.65 decimals for a consideration of 1 crore 46 lakhs. Not pausing here for a moment. So therefore, this oral agreement which they say, is dependent on happening of reciprocal obligations. So, the trial court, even here, one has to see to visualize or gather, this oral agreement, these two deeds becomes the most important deed, where a slightest of indication to the extent that this has happened in view of the oral agreement and this is a reciprocal obligation which is being complied with, being briefed not present in those deeds. The trial court held that there is no indication, iota of indication, where court could have slightest of presumption that there was any oral agreement in existence. Now, may pausing here for a moment and taking to the deed, kindly turns to page 42 of the first, 52 of the first volume. And one of the argument is, this 1 crore 24 lakhs, was a concessional price. I tell your lordship, their approach to the court is, they were dealing with the properties in phase by phase manner, and they were purchasing lands. Now, in phase by phase manners, when they are dealing, my lord has seen this dealing starts with much ahead of the oral agreement since February 2013. So, from February 2013, they were started purchasing the properties of Pal family. Now, to make up this case, since they have purchased from that period till March 2013, when they sought that the oral agreement came into existence, they make a plaint case that during this period they were making purchases, and we have agreed to enter into an oral agreement in this reciprocal obligations. Now, this 52 page, is the deed which they refer to herein, we being the purchaser purchasing his property. Now, this deed was entered into first day of November 2015. This date is also important. Now, kindly turns. My learned senior friend is unable to show any line or statement. So, it is not there. I cannot also show which is not there. But what I show from here is, kindly takes up. Kindly takes page 63. Sees the memo of consideration is 1 crore 24 lakhs. Now, they say this is at the concessional price. Now, in the agreement, I could not find any line, of saying, this is sold at a lower value. Rather, at page 56, in one of the recitals in the deed, this first whereas of page 56. And whereas the vendor has agreed to sell and the purchaser above named has agreed to purchase all that said plot together with the right to use in common with the vendor herein, the said passage more fully described in the schedule hereunder, written free from all encumbrances whatsoever at or for the agreed consideration on the agreed terms. So these terms were agreed upon. Now, my lord, then, my lord, now this indenture witness, my lord, on the same page. Now, this indenture witness that in the premises aforesaid and in pursuance of the said agreement and in consideration of a sum of rupees 1,24 lakhs only duly paid to the vendor by the purchaser on this date of execution of this deed, the receipt whereof the vendor above named doth hereby also by memorandum of hereunder written admit and acknowledge and from and from the same and every part of thereof acquit, release and discharge the said plot of land hereby sale, transfer and convey or intended to be the vendor above named doth hereby sell. Now, my lord, usual recital comes in. So, my lord, it is the what we have agreed to the consideration, my lord, that was, and my lord, the terms have been reflected here. My lord, this is an independent sale and agreement as they were approaching.
It does not say it's at the market price in the document deed. It says agreed consideration. So agreed
Yes.
leaves it open for it to be either. Obviously, it's a negotiated amount then.
Absolutely. So, my lord, it has nothing to do with an oral agreement. My lord,
Neither does it. Neither proves nor disproves that this is below the market value or.
Now, my lord, this
concession.
would be evident, my lord, from
Yes.
my lord, the
And also agreed terms and pursuance of the agreement are indicated here.
It is said.
Yes.
Pursuance of the said agreement.
yes, said agreement, my lord, this agreement. My lord, it doesn't refer to
This
any,
is
my
a
lord,
deed,
this is the deed.
not an
My
agreement.
lord, the above paragraph at stated here in above. So, my lord, it's not, my lord, anywhere other ways here.
Agreed consideration on the agreed terms, page 56, the
Yes.
second paragraph. Agreed terms is mentioned.
Yes. Consideration, yes, my lord, in person aforesaid
If
and
there
in
was no
person
prior
of the said
agreement,
agreement.
why does the term agreed expression agreed terms come in?
My lord, agreed terms because the vendor independently has agreed individually.
All right.
So, my lord, that is the agreed consideration. In
The
any
idea-
sale, my lord,
the
there
idea-
has to be, my lord, an agreement, my lord, between the parties.
As you said, in every transaction there has to be.
There has to be, my lord, some agreement.
Good.
So, my lord, this is that agreement which is referred to.
Yes.
Now, my lord, to the market price, kindly turns to page 69.
Yes.
Now, it's got that, my lord.
Yes.
Now, my lord, this page 69 is, my lord, the government of registration stamp revenue, my lord. My lord sees the market value is 1,24 lakhs, which we have agreed. So, my lord, the law is,
So
my lord,
your agreement is 1,24
1,24 lakhs.
which is less than this.
Less than this, 88,000 is more of the market. So, my lord,
but
we
it's
pay.
less than the market value indicates that it was
My
concession.
lord, 88,000 concessional, my lord, if it's concessional.
What is concession to you, your client?
Absolutely, my lord. So, my lord,
88,000 is quite concessional to us.
so, my lord, whatever, my lord, it's an independent agreement, my lord, between the parties. We leave 88,000, my lord. So, my lord, stamp duty is paid on, my lord, this 1,24 lakhs, 88,000. So, my lord, it is nothing much beyond so concessional to, my lord, have an indication to the effect. My lord, it's a concessional sale which is happening. My lord, premium value, my lord, this is the premium value because government set forth value is 75 lakhs. So, my lord, we are on the market value which is going on. So, my lord, it's not, my lord, we are selling at the government circuit rate, which is much below.
The law is that whatever is the higher you have to pay.
So, my lord,
If your agreed sum is higher, then you have
my
to
lord,
pay.
memorandum is also 1,24. So, we are paying, my lord, 88,000 extra on this stamp duty.
Extra.
Extra, 88,000. So, my lord, my contention from this deed, my lord, which is the reciprocal obligation as indicated, my lord, doesn't reflect any kind of indication to the oral agreement of 7th of March. Now, my lord,
7th of
the
May.
7th of May, sorry, 7th of May. Now, my lord, second point of argument is, my lord, the other deed, my lord, which they, my lord, in the reciprocal obligation they refer to, my lord, is also, my lord, as we have taken a stand, my lord, shown by them in the written objection that we have purchased that land, sold that land, that money has been invested here in purchasing this land. Now, my lord, that deed has not been annexed, my lord, to paper book, but we have in the affidavit in opposition. My lord,
It is there in CAN 3,
খুঁজে পাইনি ক্যান্সিতে
Can three
কোথায়
তে
গো? আমি দেখতে পাচ্ছি না
but it's there in CAN 3.
my lord, then it's there, my lord, I slipped
CAN
it.
3 তে আমি পেজ বলে দিচ্ছি।
পেজটা একটু বলো না ক্যান 3 তে অপোজিশনটা আছে কিন্তু অ্যানেক্সচার গুলো নেই
CAN 3 मतलब at page 45.
45 45 ক্যান 3
না, ওই পেপার বইতে নেই।
পেপার বইতে নেই, সেটাই তো বলছি
ক্যানে
ক্যানে আছে
ক্যান।
পেপার বইতে মিস হয়ে গেছে
পেপার বইতে annexure দিই
হ্যাঁ, annexure-টা সেটাই বলছি।
Affidavit of service.
it is there in the can.
Yes, yes, in the can, my lord, in my opposition also it is there. My lord can take note of that. If my lord takes up the opposition, my lord, since I have looked into the opposition, my lord.
So we have taken up the can, you can refer to the
Refer to the internal pages.
Yes, that will be better.
So, my lord, this is the other deed.
Yes.
My lord, kindly sees where, my lord, we are the vendors. Now, my lord, kindly takes up the relevant page. Internal page 7.
Page 7.
My lord, the last whereas of that page. My lord has got that.
Yes.
And whereas the owner stroke vendor of the first pal, while thus being absolutely seized and possessed of the said property, having their jointly 16 annas, right title and interest in the same, on account of their bona fide need and urgent lawful necessity have interested, agreed, transfer, convey the said property more fully described in Schedule A herein below, since been more particularly delineated and depicted in the plans annexed herewith by red border line forming part of the deed conveyance and undivided 1/7 share in the aforesaid common person joint individual properties more fully described in items number 1 and 2 of the Schedule B herein below. Since been more particularly delineated and depicted in the plans annexed herewith by green border line forming part of this deed of conveyance as fully, entirely and absolutely free from all encumbrances, and they have the only sellable or marketable right, title, and absolute authority to sell, transfer, convey the same in favor of any person of their choice, and the purchaser of the second part after coming to know about the aforesaid intention of the vendor. So, my lord, first we have proposed to sell, my lord, as usual, my lord, in individual sales. We have proposed to sell, they have come with an intention to purchase. And believing upon the aforesaid representation, assurance and confirmation made on the part of the owner stroke vendor of the first part have become interested to sell the same and propose the owner vendor of the first part to sell, transfer, convey the same in its favor, subject to or provided the said property more fully described in Schedule A herein below. But then, my lord, usual paragraphs again come in, my lord. Then, my lord, kindly turns to internal page 9. My lord, then proposed to be sold, my lord, the first line, and depicted in the plans annexed by green border line forming part of this deed of proposed to be sold under this presence found to be free from all sort of encumbrances or legal at a total consideration of 1 crore 46 lakhs, only as fully described in memo of consideration, have also accepted the proposal of the purchaser of the second part and transfer and the same in its favor. So, my lord, then again, my lord, then now this witness, this part, my lord, again, my lord, this 1 crore 46 lakhs is written. So, my lord, it's absolutely an independent transfer, my lord, where we have proposed to shown our intention to sell. They have, my lord, come, inquired the market, and my lord agreed to, my lord, purchase at this agreed consideration of 1 crore 46 lakhs. Now, my lord, similarly, my lord, here also, my lord, the stamp duty has been paid on the market value, my lord. There is no indication of any concessional price. The agreed price is, my lord, there. And my learned senior friend, my lord, doesn't dispute or deny, my lord, there is no factum of presence of any, my lord, indication of oral agreement. This fact is, my lord, admitted. Now, my lord, in addition to that, I have shown, my lord, the terms which shows, my lord, independently in each individual case, parties are agreeing. My lord, now, my lord, kindly referring to another deed which is beyond the reciprocal obligation, my lord, which has been entered between Devashish Pal, my lord, and, my lord, the purchasers. Because their cases, my lord, they were gradually, my lord, purchasing properties, my lord, for acquiring, my lord, for the industrial park. Now, my lord, that deed, if my lord takes up, my lord, at page 146, volume 2, now, my lord has got that, my lord. This is, my lord, kindly marks 25th day of April 2014. So, my lord, it is after the oral agreement. So, my lord, this deed also must contain, my lord, this purchases in pursuance of, my lord, the agreement which has been arrived at. My lord, kindly says the vendor is Devashish Pal. And my lord, this has several averments to that extent, my lord. For example, my lord, kindly takes 150 because this includes several plots. Now, my lord, the last part of 150 page, and whereas the present vendor herein agreed to sell due to urgent of money and the purchaser agreed to purchase the Sully land. So, my lord, similar averment in everywhere, my lord, of this deed. So, my lord, I'm not troubling my lord with each and every page because I've gone through, my lord. There is no indication whatsoever, my lord, of any oral agreement. So, therefore, my lord, in my respectful humble submission, first point of the trial court, my lord, leaving aside, my lord, the Stamp Act and my lord, all those, my lord, the trial court, my lord, tried to find out any indication of any existence of any oral agreement to grant any form of injunction. My lord, in all these deeds, my lord, which have been produced by the parties, my lord, there is nothing that sort of, and it is admitted at length now. And my lord, the averments, my lord, I could have understood there is no indication of that. My lord, the slightest of indication I could have understood. But the averments are entirely different. And my lord, the concessional price, the argument, my lord, sold at a concessional price is also, my lord, takes a backseat in view of the, my lord, fact, my lord, in the deed it records the parties have agreed to each and every sale. Now, my lord, this is with respect to the deeds. Now, my lord, my next line of argument to show, my lord, there is no, my lord, oral agreement whatsoever is, my lord, the document which they have, my lord, in their argument also relied upon, my lord, is that mutation before the BLR. Kindly takes up no, prior to that, my lord, the sheet anchor of their case. Let us take, my lord, the letters which they rely upon because this is the sheet anchor. Now, my lord, kindly takes up volume 1 for once. Page 81 is the first letter, my lord. Now, my lord, kindly marks the date. This is of 23rd of September 2016. Now, my lord, taking for a moment, my lord, there was an oral agreement, my lord, in May 2013. So, my lord, after a span of more than 3 years, a letter comes, my lord, surfaces, my lord, on record. Now, my lord, the reciprocal obligation, my lord, starts, my lord, if I say after the oral agreement, the deeds are which are there, my lord, since 2014. And my lord, the reciprocal obligation, my lord, ends in 2015. So, my lord, after a span of from there also, my lord, a span of, my lord, a year has passed. This letter, my lord, is now, my lord, written by them. Now, my lord, may I just place the letter? Pursuant to the discussion and negotiations between yourself along with Sri Jagadamba Singh and ourselves, you have agreed to sell your land, property situated at Mouja Vipannopara, jail number such and such, Mouja Mohari, Domjur, Howrah. It was represented by you that the landed property comprises of 3 parts as follows. Your 1/7 undivided share having an area of about 170.90 decimals in the joint property at Mouja Vipannopara, owned by you along with Sri Nimai Chandra Pal and others, Sri Surjakanta Pal and others, Sri Pradeep Kumar Pal and others, Sri Arup Kumar Pal and another, Sri Prabir Kumar Pal and another, and Sri Partho Pratim Pal. divided and demarcated piece and parcel of land measuring about 200.17 decimals situate partly in Mouja Biponnopara jail 27 and partly in Mouja Mohiari jail number 28. 1/7 undivided share having an area of about 11.86 decimals in the common passage, comprising partly in Mouja Biponnopara jail 27, partly in Mouja Mohari jail number 28. In part performance of our agreement, you transferred and conveyed in your favor the land measuring about 170.90 decimal, being the undivided 1/7 share in the joint property as stated in paragraph 1 above on 25 April 2014. So, my lord, this part performance, my lord, issue, my lord, the deed at page 146, this is of this 25th April 2014. In my respectful humble submission, my lord will not find that agreement in the plaint case made out. In the plaint case, the awardment which starts in paragraph 4 is, my lord, the following effect, after which first is the defendant number 1 shall convey the total area of 3.860 acres of land to the plaintiff at an agreed. This is includes the undivided and divided entire at 6 crores 88 lakhs. Second, the suit property was mentioned in C. The party kindly takes up page 13 for once, my lord, for tallying, my lord. The partitioned area 151 decimals, 46 land, which is such and such. Then third, the obligation, which reciprocal obligation now comes in, my lord, is the selling of 65 decimals by, my lord, the defendant, the plaintiff to defendant number 1. Then after that, transfer by the defendant number 1 to the plaintiff of 65.64 decimals. Then, my lord, upon mutual transfer of land as aforesaid, the suit property would be transferred.
Chronology is different.
Chronology is
They tried
absolutely.
to say in the letter that that was subsequently altered by your request.
Yes.
In this letter for
this letter. So, my lord, this doesn't tally with the effects, my lord, of
in
that
the plaint, this alteration is not mentioned.
not mentioned,
No, just a minute.
my lord.
This clauses you are showing at page 13.
13.
Plaint says it is the purported oral agreement which records this.
Absolutely, that's my point, my lord. So, my lord, I say, my lord, the letter indicates of the oral agreement.
Of 2014.
Absolutely. So, after the oral agreement, now, my lord, the letter starts with in part performance. My lord, the part of the letter starts in part performance our agreement. So, my lord, it's an so therefore, my lord, this is
The sales do not match the chronology given in the plaint, which
Not
were the
in the-
terms of the oral
absolutely.
agreement. And they refer to an altered agreement which is not pleaded in the plaint.
not pleaded in the plaint. And, my lord, they are not seeking, my lord, enforcement of the altered agreement also. Now, my lord, may I just read on? On 25th April 2014, by 4 several deeds of conveyance registered in office of additional district sub-register Domjur Howrah and received payment of total agreed consideration amount from us. My lord, in the next page, the first paragraph is the reiteration of the last part. So, my lord, I'm skipping over. Although, my lord, the second paragraph onwards, although according to our original agreement of sale of your divided and demarcated piece and parcel of land measuring 200.17 decimals was to be conveyed first, we had agreed to your request to take conveyance of your undivided land measuring about 170.
This is what we are saying. This is not pleaded in the plaint.
This is not pleaded in the plaint. Measuring about 170.90 decimals upon your assurance that conveyance of the divided and demarcated parcel of land along with your 1/7 right in the common passage shall be transferred immediately thereafter. Thereafter, on 1st November 2015, you transferred, my lord, which is at page 52, and conveyed a part or portion of the said divided and demarcated parcel of land together with 1/7 undivided share in the common passage, altogether measuring 65.640 decimals at Mouja such and such in Mouja Biponnopara, leaving balance 150.220 decimal. It was assured by you that the remaining parcel of land measuring 150.229 decimals shall be transferred and conveyed as soon as the sale of parcel of the land by other co-owners who had also agreed to sell their respective undivided share in the said land, as well as their divided and demarcated plots together with each of their undivided share in the common passage is completed. In view of of your commitment as already stated above, we have acquired the right title and interest of co-owners, and in order to complete the transaction, you are now obliged to transfer 150.229 decimal in the said piece and parcel of land. Since we have already invested, well, kindly mark this, since we have already invested large sum of money based on the commitment made by you, we would request you to kindly arrange for immediate transfer of 150.229 decimals in the said piece and parcel of land together with another 65.64 decimals of parcel of land agreeing to such and such. So, my lord, this part, my lord, in my respectful humble submission is, my lord, showing and, my lord, desire, my lord, to purchase my land, making out a case that we have entered into an agreement.
This is pleaded in the plaint.
This is pleaded in the plaint. So, my lord, this desire, my lord, to purchase and, my lord, eagerness to purchase, my lord, doesn't lead to, my lord, an oral agreement. This is another point. My lord, third, my lord, their argument is, my lord, we have not replied. Admittedly, we have not replied. Now, my lord, to form and concluded contract, my lord, offer and acceptance is must. So, my lord, it is not their case. Non-reply of this letter has formed the oral agreement, because oral agreement has occurred, my lord, way back in 2013. So, my lord, if they fail to show there wasn't any existence of oral agreement as of 7th May 2013, my lord, my reply to this letter makes no sense. And if
No, but they have stated, Mr. Chatterjee, that in terms of the commitment made by you, in view of the commitment made by you.
Yes. So, my lord, unilateral letter, my lord, doesn't create a concluded contract.
No, not unilateral. In view of commitment made by you, they say. Last paragraph of this page 82 says, in view of your commitment as already alleged above, we have acquired the rights. Since we have already invested such and such, this is in continuation of that. And again, they say, since we have already invested huge terms of money based on the commitment made by you. So they referred to a concluded contract in this.
That's exactly my point.
Commitment.
My
Not
commitment,
that desire only. From the letter, since you are.
so, my lord, my commitment doesn't happen, my lord, by responding to this letter. My commitment, my lord, or agreement, my lord, prior.
Yes.
So, my lord, in this
So
letter,
by not responding, you have not denied this. That is their case.
so, my lord,
Prima facie.
so, my lord,
It is not a pleading, you did not have denied as such, but your contemporaneous conduct, their own conduct. So you did not deny this.
so, my lord, yes. So, there, my lord, case,
That
my
is
lord,
their case.
that is, we have not denied this. Admittedly, we have not denied this. My lord, having not denied doesn't mean, my lord, having agreed to anything. My lord, in case of an oral agreement.
No, why should that mean agreeing to it?
No, my lord, I take it to the extent
But
to
they
show,
say
my lord,
prima facie case.
to the court, finding, my lord, the existence of an oral agreement.
Yes, that is
So-
the entire premise of your argument.
So, my lord, there in
You're
this letter,
justifying that finding of the court, obviously.
now, my lord, in this letter also, my lord will find no reference to an oral agreement dated. My lord, it is always we have agreed.
All right.
So, my lord, when 2016 letter is being drafted, my lord, they also didn't knew, my lord, there was an oral agreement. My lord, it is only, my lord, the advocate's brain.
This was also some other advocate.
Some other advocate. So, my lord, it was, my lord, my lord, similarly, my lord, this letter has been, my lord, reminder letters have been sent, my lord, without again, my lord, those letters do not refer to any oral agreement.
Commitments are mentioned.
Commitments are mentioned.
So similar.
Similar, but, my lord, very cryptic. In those letters, those are very cryptic. My lord, just a two-liner reminder. We have sent you that letter. My lord, just reading one letter, my lord.
Yes.
Page 84.
So they refer to the earlier letter and
Yes.
Yeah, right. All right.
Now, my lord, there secondly takes up, my lord, their volume 5, because this is one of their argument also, my lord, that after, my lord, purchasing serially, my lord, from the Pal family, my lord, they have started, my lord, engaged, my lord, and person, my lord, to construct the industrial park. And, my lord, they entered into a development agreement with such person. Page 549.
Yes.
Now, my lord, this agreement, my lord, will find entered on 12th day of July 2016. So, my lord, that letter comes in September. Now, my lord, this was entered just few months back. Now, my lord, the relevant portion, my lord, which I will refer to, my lord, is at page 556.
Yes.
I will find the first 4.2 just above. The said SME Industrial Park project will also include various other lands which may be brought or acquired by Messrs. Alok Nivas Private Limited and Messrs. Satkaram Wind Trade Private Limited and or contributed by others from time to time, and SD Infrastructure and Real Estate shall enter into similar agreements from time to time for which no consent or approval from Messrs. Alok Nivas and others would be necessary. So, my lord, it is, my lord, in dilemma. There also no, if there was any oral agreement that they are to purchase, my lord, then may is, my lord, I say, my lord, this is something, my lord, shows, my lord, yet as of that date, my lord, there was nothing but only an intention to acquire, which they referred to there in letter. An intention, my lord, to purchase further land.
All right. Yes.
Now, my lord, page 561 of that,
Yes.
my lord, 9.1. In as much as SME Industrial Park is proposed to be developed by SD Infrastructure and Real Estate Private Limited for the time being in force on the first scheduled property and second scheduled property, and the intention of Messrs. SD Infrastructure and Real Estate Private Limited, Messrs. Alok Nivas Private Limited and Messrs. Satkaram Wind Trade Private Limited is to expand the total project area by acquiring more lands by enter into similar agreements with other contributing landowners. From time to time, the entire project shall be completed in several phases. So, my lord, exactly what he has argued. My lord, they were purchasing one-to-one in phase manners. My lord, there was no oral agreement as such with the Pal family. That's why, my lord, in every deed, my lord, in every sale, my lord, it is agreed individually to the consideration. And this is what been, my lord, given impression to the developer that you start the work, there will be further lands coming, my lord, entering into similar agreements. My lord, similar agreement here can only be the agreements, my lord, of, my lord, with the other, where they in the plain they say there were written agreements by the defendant number 5 who acted as a middleman.
So their attempt to create a common thread in all these
Yes,
in a single agreement, that is incorrect.
that is
Phase-wise purchases, each time there's an agreement and sale.
agreement and sale.
Independent deeds and considerations.
Independent deeds and consideration. Now, my lord, after, my lord, all this, my lord, now, my lord, the vital part, my lord, which they have also referred to, my lord, is the, my lord, the before the BLRO, my lord, the joint declaration. No, paper boy থেকে দেখাতে হবে। Paper boy এ marking আছে। My lord, that is at page 232, volume 2. My lord, this is, what has got that?
Yes.
This is of 2015 November 2017. My lord, the date would be, my lord will find at page 235, the last signature, my lord, there is a date referred to.
Yes. Yes.
So, my lord, in this, my lord, the first page kindly turns to the first page for the timing. Now, my lord, the last part, both the parties, my lord, the parties here are Devashish Pal and Alok Nivas. Both the parties have sat together and it has been mutually agreed between them as follows. My lord, so they are, my lord, while mutating, my lord, they are saying, my lord, which lands are exclusively owned by them, which are to be shared. My lord, as per the deeds already entered into and executed. So, my lord, now the change of record of rights are happening. Now, my lord, to this, the last in every part, my lord will find the name of Devashish Pal, the other owners, the Alok Nivash, everything is mentioned. For example, my lord kindly takes up the first, second page 233. My lord will find Roman 3 in LR plot numbers.
Charts and their shares and all.
Yes, my lord, the fourth is Devashish Pal, and the last, my lord will find name of Alok Nivash.
Yes.
So, my lord, they are, my lord, entering into record of rights, mentioning their name to the extent of their shares, my lord, on the land. Now, my lord, lastly, my lord, this is vital, my lord, the Roman 4. The area in the other LR plot should be recorded in favor of Alok Nivash Private Limited as per their application and supporting papers, and the residual areas in the said plot should remain in unaffected khatyans or in the khatyans with unsold areas. Now, my lord, error plot in which Devashish Pal have 100%. So, my lord, therefore, my lord, this is done in 2017. So, my lord, after, my lord, the oral agreement, and, my lord, after, my lord, the reciprocal obligation in as per them has been completed on their part, as well as one of the obligations on my part. Now, my lord, in 2017, my lord, they both sat together. My lord, first reference of sitting together in 2017 for the purpose of recording LR record of rights, where also, my lord, we identify which are absolutely owned by us.
They don't say that we have sat together in 2017. They
Yes.
say both parties have sat together and it
No.
has been mutually agreed.
So, my lord, for this purpose.
Yes.
So, for this purpose only. There is no other purpose.
For the purpose of mutation only.
For the purpose of mutation. And this also, my lord, the parties have individually, my lord, agreed which is absolutely owned and which is, my lord, jointly held by each other.
Very.
My lord, these are indicating factors, my lord, there was no existence of oral agreement, I'm saying. My lord, my endeavor or the, my lord, to support the trial court's judgment, my lord, I'm just indicating, my lord, all documents, my lord, which were brought before the court doesn't suggest even, my lord, of slightest of imagination that there was any existence of oral agreement.
Yes.
Now, my lord, to show, my lord, to have a clear picture, my lord, why they, my lord, make out this case. Now, my lord, my lord, with an agreed to acquire the property, my lord, kindly takes up, my lord, the map which they have also relied upon to a deed annexed. That would be available, my lord. My lord, I was referring to, my lord, page 232, kindly turns to page 236. My lord, the picture is clear, my lord. My lord will find this white area. My lord, is the area, my lord, which they intend to purchase now. And my lord,
Better if your lordship comes to the
This one.
the
Yes.
in can, yes, not that. but
Can a
in
better
can,
picture,
huh,
na?
in can
but in a
3,
paper book, this has become very hazy.
in can 3, if your lordship comes to page কোথায় ছিল ওটা?
Lord, in the can 366, the page number 366. That is a better picture. Can
can 3 তে ছিল।
What about page 89? This is something else.
89, my lord, of the can.
Yes. Well, kindly
89
take
is also-
89. 89. Yes. So 89.
89.
তুমি এটা থেকেও দেখা
হ্যাঁ, হ্যাঁ, ঠিক আছে।
এটা থেকে দেখা।
My lord will find, my lord, the white portion 65.64 decimal, my lord, this which is written
First,
I,
your picture just
Milord, this one. I, Milord, written I.
I. Very.
Milord,
The
this is the
foundation.
land
Huh.
which they intend to, Milord, purchase from us. Now, Milord, this is just, Milord, on the right-hand side, my lord will find the common passage. And, Milord, the right-hand side, B plus G plus 4, which is written, Milord, that is the, Milord, property of the plaintiff, which they have faced by manner, Milord, purchased from us.
That existing building.
Yes, existing building, Regent International.
Yes.
That is the property which.
Yes.
Now, Milord, what they are saying, trying to do is, Milord,
The strike portions are there. They have already acquired
they have already acquired.
and constructed probably in some
Constructed.
portions. Under construction. Right.
Yes. Now, Milord, here, Milord, they intend to, Milord, now, Milord, say that they take the entire, because they have already
Covered the entire
constructed.
area.
Yes. Now, they have already constructed a gate here, my lord will find. Its gate is belonging to them. Milord, they have constructed the gate. Milord, gate is not in my control. Milord, on the earlier occasion, I have just
Where
handed
is the
over.
gate?
I will find just under the construction, a gate under construction road. Milord, here.
Oh, yes.
So, Milord, this gate has been constructed by them. So, Milord, now, Milord, as agreed between the parties, that we both will have common access through the common road. So, Milord, now if we go out, then it will be in exclusive control and domain of theirs, because there is their
They
gate.
openly want that. They openly
They
want
openly
the
want that.
thing to come
So,
within
Milord,
the
now, Milord,
construction that
my
park.
endeavor is to show, Milord, this making out of case is because of this. Milord, there was no oral agreement. Today, if I agree to them,
So what does want stop and greed start?
no, I have no.
Want has a greed.
I have no
every greed has a
qualms,
want.
Milord, if they say we intend to purchase, but if they
They
say
have money, they want to purchase.
they want to
you don't
purchase,
want to sell.
I don't want to sell.
You also maybe have money, we don't know that. But you don't want to sell.
I don't want to sell.
So I mean, this greed and all these are.
Milord,
this prejudice is not applicable to. This is a commercial construction. There.
Commercial. Now, Milord, that would be, Milord, my
That does not mean that you had greed when you sold the other portions. This is not a question of greed. It's a question whether they have prima facie been able to show something regarding an oral agreement.
Yes. So, Milord,
They openly want this
No.
to cover up because you are an eyesore to them.
so exactly, Milord. Now,
Not only stopping at eyesore, it's logistically also easier for them.
Now,
That's
Milord,
very evident.
Now, Milord, to this, Milord, their language in the, Milord, the development agreement is very clear, Milord. They want to purchase. It's not that they have already, Milord, entered into an agreement. They will enter into several agreements for purchasing further lands.
They're doing that. They're openly. That is the function of a developer.
Yes.
They're trying to develop the.
So, Milord, this factum of oral agreement doesn't, Milord, see that the light of the day, Milord, in any of the documents.
How does the map help you?
Milord, map.
Greed.
Milord, why they, Milord, now, Milord, in the plain case, they start doing this. Milord, I am showing, Milord, their conduct. Milord, they have shown my conduct. Milord, I am showing from the
What
document.
is
their conduct is to, Milord, put me into litigation. Bring on litigation. Fight out litigation. Milord, Milord, my lord knows, have an experience, Milord. Sometimes
that is counterproductive to a developer also. Sometimes the developer want the converse. That will be entering into conjecture and surmise strategy, because we are saying, frankly speaking, we have seen more developers being embroiled in litigation by the individuals just to extract more money than developers doing it. Developers want to be as litigation free as possible. They can't avoid it, therefore they enter into litigation. Developers want to resolve
Milord,
disputes by paying money.
If I don't break,
that may work either way.
Yes, Milord. So
they also try to embroil them in litigation so that it's counterproductive to them, and they want to settle by someone. So it may be either way.
So, Milord, there is a possibility also,
us
Milord,
much.
to this filing of the plate. Milord, it's either way, Milord, there is a presumption to the other side also. I'm taking that presumption on the other side.
Yes. So those cancel out each other. Your greed cancels out vice versa.
So therefore, Milord, today.
But the other arguments you have made, this also you are taking note.
Yes. Now, Milord, note that. Now, Milord, my second limb of argument, Milord, is kindly takes up, Milord, the plaint for once.
What is the argument? Tell us and then just come.
Yes. The argument is, Milord.
Yes.
From the plaint, Milord, I will show, Milord, the prayer, Milord, which they now say, Milord, one of the ground, Milord, the court says there is no common passage in the schedule, therefore, I have not granted. the injunction.
Hmm.
Now, my lord, kindly takes up the prayer portion for once in the plaint. Rather, my lord, kindly takes up the injunction application. That would be, my lord, better. Injunction application, my lord.
120.
Injunction application.
120.
What has got the injunction app?
Yes. Prayer portion at 143.
Yes. Now, my lord, may I just place the prayer in the injunction? An order of injunction restraining the opposite parties, respondent number 1 and 2, and their men and agents or servants from changing the nature and character of the suit property, making any construction thereon, and restricting free ingress and egress of the petitioner from common entrance on the National Highway 6 to the suit property. My lord, marks here, my lord. My lord, they want, my lord, and free access to the suit property where I am in possession. So, my lord, this cannot be granted.
Oh, acha, to the suit property.
To the suit property. It's not their case, they are not having access to their property.
And they continue further as also the plots of land owned by the petitioner. Acha, wait. All right.
So, my lord, this part to the suit property should be discarded because I am in possession, my lord, I have already constructed, that has come up before my lord. So, my lord, at the, my lord, pendency of a suit, my lord, he cannot have a free will, my lord, to enter in my property. So, my lord, I will, my lord, it goes without saying, my lord, if anybody tries to forcefully barge into my property, my lord, he will face resistance. So, my lord, court cannot grant that leverage, my lord, to enter into somebody's property. So, my lord, this injunction, my lord, in a circuitous manner, my lord, is a final relief when execution would come to, my lord, sell the land and deliver possession.
But that it has another link that also to the plots owned by the.
My lord, it is not their case, my
Is
lord.
on the
That
merits.
is, let them have. My lord, I am conceding. My lord, I will also enter, they will also enter.
Very.
Because it's common.
Oh, acha.
The same road leads to that. That's why, my lord, the map is important now, my lord.
This part, the second limb, you don't have any objection.
No objection. Let him enter to his property.
So
I will also
it is
enter.
like that.
Yes. But his principle is to, my lord, free ingress to the suit property. Now, my lord, kindly sees, my lord, the nuisance factor which they plead. Prayer B. An order of injunction restraining the opposite parties, respondent number 1 and 2, and their men and agents or servants from creating any nuisance on the common passage leading to suit property. So, it's always to the suit property.
It has been so ingrained in the public mind about committing nuisance that
Yes.
immediately when they say of creating nuisance, we think of something. Are you doing that also?
No, my lord, that's that. I'm saying you enter your property, I will enter into my property. Why do you need and my lord?
So, but don't create a nuisance. They're entitled to.
I'm not. They are not. It is not their
They
case.
also
Even.
cannot cause a nuisance.
No, I'm not. That's why exactly what I'm saying. My lord, I'm not. But they cannot buy this.
Parking vehicles on such passage.
My lord, they are merely parking vehicles.
No, they are asking you not to. They have alleged that you are parking. You have not alleged.
My lord, I'm saying take it. Because it's a common passage, my lord, we are both agreeing. And it's a metal road. So, my lord, I can also park vehicle, he can also park vehicle.
But they are saying that you are parking and blocking the passage. That is the nuisance they are saying.
Lord, let them show anything, my lord, of any nature before the court to indicate, my lord, that court has come to an finding or document showing that I was doing this.
More important is whether they have produced any document.
Produce any document to that extent. My lord, in the argument also, my lord, at the time of arguing, my senior friend, my lord, has not argued to that. So that, my lord, I need not respond on that also.
But if it's a common passage, Mr. Chatterjee, vehicles, they are making construction, vehicles need to come and go. If you park cars on the passage, then it may be difficult
It's a
for them
huge
to make
metal road, 30-feet metal road, my lord. Sideline, my lord. Then, my lord, what?
Maybe construction vehicles coming
my lord, because I am also running a hut there. So, my lord, today if their vehicle will also
You're running
enter,
a what?
I am running a hut there.
Hut.
Hut. My lord, the garment hut. Garment hut. My lord, I have also constructed, my lord, there.
You have already
I
constructed.
have already constructed and it's running, my lord.
Therefore, for you, no construction vehicles need to come in. But garment, yes.
Garment vehicle would come in, definitely, my lord.
So no material to establish that you are parking cars.
Yes. And my lord, take it, my lord, that we are not creating nuisance, my lord, in any manner. 7 except they do not try to enter into my property. My lord, it's not that they will enter into in front of my gate and say, my lord, I will block your passage. That's exactly, my lord, the first line goes to enter into the suit property, Now, my lord, kindly takes up the plaint for once, my lord. The language in the plaint would be important here, my lord. Now, my lord, my lord, kindly takes up paragraph 12 of the plaint.
Yes.
In the said development agreement dated 12th July 2016, it was inter alia recorded that the said development agreement would also include various other properties and or contiguous land, which may be brought in and or contributed by other persons, and the distribution will be done on the basis of quantum of land contributed by other parties. Such clause clearly demonstrates the plaintiff had an intention to acquiring a large area of land for the development of the said industrial park. So, my lord, statement of intention corroborating with, my lord, entering into similar agreements for purchasing, my lord, other lands says, my lord, there was only an intention, nothing more.
So it's unilateral, their intention.
There. Now, my lord, paragraph 14, my lord, would be important, my lord. Being officer of the court, my lord, I should bring notice to your my lord also. In the meantime, the plaintiff has started making construction of the said industrial park upon obtaining permission from various statutory authorities. The project, however, would remain incomplete in absence of the said area of 151.46 decimals of land. It is stated that the defendant number 1 on 3rd August 2017 agreed in presence of well-wishers of the parties that he will complete the full performance of the contract within 2 years. Milord, this is now, Milord, they say on 3rd August, Milord, there was further something, Milord, we have agreed to perform this.
Mr. Chatterjee and Mr. Rai, there is we can't remember whether we asked you. There is no scope of any compromise in this.
Milord, compromising, Milord, my client says, Milord, since he is now commercially exploiting the property.
Oh, no. We asked you, you
So,
said that you
Milord,
have already
he
made
says,
a
Milord, then, Milord, I should not only be compensated on the land value,
The
but
garment.
also, Milord, my business value. If they agree on that, if they come on that, Milord,
conclude the hearing and I will keep that open. I mean, if you want to.
yes. Now, Milord, paragraph 16.
Why did you place 14?
14 because they may argue, Milord, in reply that on 3rd August there was a further statement.
That pleading.
That pleading.
Ah, yes.
So, Milord, 7th May 2013, then, Milord, a 3rd August pleading comes in. And, Milord, my lord will find the now, Milord, the letters. In the letter, there is no reference to 3rd August also, when, Milord, the last letter subject to correction has been sent on reply letter November 2017.
In those reminders.
Those reminders at page 86. It only refers to, Milord, of the, Milord, oral agreement, doesn't refer to, but refers to an agreement or commitment of the previous letter, referring to previous letter.
Yes.
Now, my lord, paragraph,
Paragraph 16.
paragraph 16, my lord, I am just indicating, my lord, I will develop an argument subject to, my lord, what my lord says.
Yes.
The plaintiff states that the plaintiff was at all material times ready and willing to perform its part of contract. In fact, the plaintiff has discharged his reciprocal obligation and is also ready and willing to pay the agreed consideration or the said 151 decimals of land. The readiness and willingness of plaintiff will also be borne out from the letters dated such and such, such and such. So, my lord, this reciprocal obligation is part of a pleading. My lord, they base their plaint case, my lord, on a reciprocal obligation, part performance and reciprocal obligation being complied with. My lord, this I will argue, my lord, at a, this would be my last argument, my lord, in my humble submission. Because on the first occasion, my lord was not with me on this, but I'll try and develop this argument. Now, my lord, here in the plaint, my lord will find paragraph 27.
Yes.
In the facts and circumstances, the plaintiff is entitled to specific performance of the terms and conditions of oral agreement 7th May 2013, which was reconstructed on 3rd August 2017, as agreed upon by and between the plaintiff and the defendant. Insofar as the suit property is concerned, the plaintiff is also entitled to decree of permanent. So, my lord, there is a novation, my lord. If it is reconstructed, so, my lord, I say, my lord, a new form of agreement has come into picture, which term doesn't find place in the my lord plaint. Now, my lord, paragraph 29. The cause of action arose on 23rd September 2016 at the suit property and Moja Biponnopara Police Station, Domjur District, Howrah, within the jurisdiction of this learned court, when the defendant number 1 refused. So, my lord, refusal is on 23rd September 2016, and my lord, kindly see the first letter is of 23rd September 2016. My lord, if I have refused on that, then, my lord, subsequent reminders, my lord, their averment that I have not responded in a written form, my lord, doesn't lie. My lord, they were aware, my lord, my refusal. To convey the suit property in favor of plaintiff as per the agreement dated.
The date of that letter?
Letter, first letter, my lord, is of
23rd September.
23rd September. On that day itself, its refusal.
All right.
In favor of the plaintiff as per the agreement dated 7th May 2013 and subsequently on 15th February.
It might be that you had refused on that date. That's why they gave the letter on that date.
So, my lord, that letter doesn't indicate any refusal that you are refusing. Rather, they are requesting me.
All right.
So, my lord, that letter is silent on refusal.
All right.
And therefore, my lord, the presumption, my lord, of non-responding, my lord, of to the extent that accepting what they state, my lord, doesn't hold anymore.
So the non-response become immaterial.
Immaterial.
Very well.
I mean, may I just read this paragraph would be important, my lord. Favor of the plaintiff as per the agreement dated 7th May 2013 and subsequently on 15th February 2017, 3rd August 2017 and 2nd November 2017, when despite receipts of letter from the plaintiff, defendant did not convey the suit property in favor of the plaintiff.
Those are cryptic reminders.
Cryptic reminders. And lastly, on 31st of March 2017. My lord, so if 27 September 2016, my lord, is the first refusal, Milord, thereafter, Milord, only reminders referring to the offer which was already refused. Milord, when the suit was filed, Milord, I have a question, Milord, if the suit is filed beyond from that period, September 16 to after September 19, Milord, it suffers from limitation. It creates in this 29, Milord, he tries to create a cause of action by taking to the reminder letters. Milord, this reminder letters, Milord, is after my refusal.
Suit was filed when?
Suit the plaintiff,
If it's before September 2019, then it's fine.
But I have not that stamp. The paper book doesn't contain the stamp. কবে file করেছে দেখো না।
Nowadays, those
That
columns
is
are not
April
filled.
2019. I am instructed it is April 2019. তাই তো?
written in the verification April, but no date is given, so might have been prepared on anyway. But then it's within limit.
Well, that's why I do not have the stamp. That's why I was inquiring, Milord. He says verification on April, Milord. Take it, Milord. In April only it was filed. So, Milord, my point, Milord, second is, Milord. So, Milord, if refusal is in 2016, Milord, in a commercial project of this nature, Milord, period of awaiting period of 3 years, Milord, is fatal in grant of injunction.
Delay defeats security.
But the first injunction order was passed on 5th April 2019.
Then that will be the date.
That will. So, Milord, my
At
second
least before that.
At least
yes,
before.
September, before September.
April.
Milord, I would say, Milord, delay starts, Milord, to be calculated, Milord, on the completion of the reciprocal obligation they allege, because our reciprocal obligation stood completed in November 2015. So, Milord, since November 2015 till September 2016, Milord, refusal comes. He waits till April 2019.
But there was no refusal, alleged refusal on your part till
Milord, after this paragraph 29, nothing remains, Milord. They admit there is a refusal.
in 2016.
2016, Milord.
Within limitation.
Yes, absolutely.
Delay defeats security is a different argument.
So, Milord, I am calculating, Milord, in my humble submission, delays from September 2016. Milord, I stretch my case, Milord, in November 2015, because immediately I should have transferred 151 decimals. And their first reminder letter comes in, Milord, as per them is September 2016. Till such time, there is nothing to show, Milord, they were approaching me to, Milord, to convey that 151 decimal.
All right.
Now, Milord, kindly takes up, Milord, the prayer portion of the plaint. Milord, prayer B is the first prayer, supposedly. Decree for specific performance for transfer of suit property as described in the schedule herein with a direction to defendant number 1 to execute register sale deed in favor of the plaintiff on accepting agreed consideration being a sum of such. Milord, any reference to oral agreement? Milord, the other prayers, Milord, are also do not refer to any oral agreement. Now, Milord, keeping, Milord, after the plaint and, Milord, the documents which I have relied upon and they have also relied upon, Milord, the thing which boils down to is, Milord, there is no presumption, Milord, or any indication of oral agreement. Milord, in case of oral agreement, the law is settled, Milord, you have to make the strongest of the case. Now, Milord, if the strongest of the case is absent, Milord, in my respectful humble submission, there cannot be any injunction.
Yes.
Secondly, Milord, to have, Milord, an injunction, Milord, on any agreement, Milord, one has to show, Milord, there is a concludedness of the agreement. So, my lord, this concludedness of the agreement would, in case of an oral agreement, would be deciphered, my lord, from a relevant document, which in this case, more particularly in reference to 2Ds out of reciprocal obligation, in which there is no reference. So, my lord, there cannot be any finding that parties anytime, my lord, has concluded to an agreement or there was a mutuality in between them. Now, my next limb of argument, my lord, from the plaint itself, my lord, this is something, my lord, I say, my lord, the suit is not maintainable. In the sense, my lord, this is specific performance in respect of a property agreement to make a commercial project. So, my lord, it ought to be a commercial suit. Now, my lord, it was filed in a regular court, civil court. Now, my lord, if regular civil court doesn't have the, or my lord, lacks inherent jurisdiction to, my lord, enter into, my lord, a commercial dispute, my lord, it cannot pass any order even. It has, my lord, to only, my lord, either to say, my lord, the suit is not maintainable, or, my lord, at best on their application, or, my lord, at suo motu, my lord, transferred the suit to a commercial bench. And, my lord, this suit is filed of 2019, much after the commercial court has come into force. My lord, there is no doubt, my lord, this is a commercial dispute, because this agreement touching upon, my lord, and making of an industrial park, the subject matter of land, my lord, over which a park will come up.
Yes.
So, my lord, today, my lord, the dispute is of commercial in nature. Now, my lord, the provision gulo dekhachi, argument ta shesh kori.
Which provisions? Commercial code, sir?
My lord, that is, my lord has dealt, my lord has passed. I will just rely upon those decisions, my lord, and did not take, my lord, to the provisions of Commercial Code Act. Now, the argument, my lord, which I intend to develop now, my lord, is I have
Quickly
referred.
develop and end. Now you conclude your arguments.
Yes.
We won't give you much longer time.
Yes, yes.
Now,
Now, my lord,
very well, not that. I mean,
no, because
do it better.
this is something, my lord, I say, my lord, in this oral agreement, yes, I agree, my lord, there can be an oral agreement as per the Indian
Don't repeat
Contract
your
Act.
arguments. You have understood, sir. Now,
When they rely upon, my lord, and reciprocal obligation,
yes.
my lord, there has to be a written agreement. This is my argument.
Why do you say that?
My lord, I take reference, my lord,
Prove it from the conduct of the parties, contemporaneous
no, my
documents.
lord, under law, my lord, I say.
Achha, achha.
My lord, under law, my lord will chastise me in referring to section 53A, part performance. But part performance has two parts. My lord, it refers to, my lord, in case a party referred to an reciprocal obligation or part performance.
That is for a limited context.
Yes, that's exactly, my lord, that exactly, my lord, my point.
Are you arguing that, Mr. Charith?
I am arguing because on the support of, my lord, and judgment passed by Honorable Supreme Court saying, my lord, even if my lord, even if it is used.
It can be an offense. Assured.
Yes, that's exactly, my lord.
Start with the judgment.
But exactly what I was on that. But I was when I found it, my lord. The reference to the which.
So therefore, registered agreement is necessary.
No,
Registered
for the time
written-
being, my lord, I am not on the register, but a written form.
No, 53 includes written and registered.
Yes.
Now it's registered also has come in. Previously it was written on.
Yes. Yes. Now, my lord, kindly takes up 18-16. My lord takes up 2018-16 SCC page 725. My lord, paragraph 16. My lord directly comes to paragraph 16. 16. 16. আচ্ছা extra copy ওদের এটা দাও
Paragraph 16.
Paragraph 16.
Yes.
In the instant case, respondent number 1 and 2 filed an original suit for specific performance of contract on the ground that the owners of the suit property transferred the entire possession of the property to them after agreement to sell, and it was done in pursuance of part performance. So, my lord, suit is based on a ground of part performance. Hence, the plaintiff are entitled to benefit of Section 53A of the Transfer of Property Act 1882. In short, TP Act, Section 53A, which was added in 1929 and imports into India in modified form of equity of part performance as developed in England in Elizabeth Madison versus John Alderson. The following postulates are sine qua non for basing a claim on Section 53 of TP Act. Similar, the pleading refers to reciprocal obligation being performed. He has performed his part, he files a suit on that. So therefore, this sine qua non, the point 2, the contract must be in writing signed by the transferor or by someone on his behalf, comes into picture. Similarly, even a suit which is based on this ground.
All right.
So therefore, in my respectful humble submission, 53 comes into play.
What was the suit for specific purpose?
Specific purpose.
Yeah, it's stated here. Let us see Section 50.
Yes.
TP Act into transfer property.
And my lord,
The A itself has been amended.
53 doesn't speak of registration, but
The A, the
it refers to writing, but registration is in
that
the
has not been
registration.
amended now.
In contemplation of this, my lord, Registration Act has been amended, incorporating registration, whoever comes under 53A.
একটা বাঞ্চ আমাকে দিন, আমি দেখছি।
Not
কালারটা দেখে নিন, ওই কালারই মনে হচ্ছে আমাদের আছে। একটা আছে তো ওনার কাছে, আপনি দেখুন আছে কিনা।
তোমার কাছে আছে ট্রান্সফার প্রপার্টি অ্যাক্ট?
বাঞ্চটা দিন, আমি দেখে নিচ্ছি। একটা বাঞ্চ দিন, একটা বাঞ্চ দিন। একটা দিয়ে কি হবে? একটা দিন। দুটো রয়েছে না পরপর? একটা নেই? থাক, থাক। ওনার কপি নেই তো। Yes, you don't have a copy.
No, I don't have. My lord, can you look into? My lord, may I use the mobile, my lord, to refer to that?
Please do, please. Absolutely.
My lord, may I place 53A? Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee, being already in possession, continues in possession in part performance of the contract, has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding that, where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed, therefore, by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and the person claiming under him any right in respect of the property which the transferee has taken or continued in possession other than a right expressly provided by the terms of the contract, provided that nothing in this section shall affect the right of the transferee for consideration who has no notice of
Things,
the.
Mr. Chatterjee. One is that the section begins with where any person contracts to transfer for consideration by writing signed by him. So the rest of the section is applicable only if there is a contract in writing
Absolutely,
pleaded by them.
that's exactly, my
They
lord.
have not pleaded any contract in writing.
No, they have not pleaded.
So therefore, the rest of the section does not come in. Therefore, the defense is not based on this section 53A.
No, my lord, it's not defense. The Supreme
So
Court says.
their offense. The suit is not based on section 53A. Supreme Court applies that sine qua non to a claim based on 53A. Now 53A starts with where any person contracts to transfer by writing. They are not relying on any written document. If they had relied on a written
But
document,
I
then it's
say,
not
my
for-
lord, I say, my
and
lord,
that too, the after notwithstanding, the section is very clear. Shall be debarred from enforcing against the enforcee other than a right expressly provided by the terms of the contract.
my lord, I follow what is following, even when I was thinking, but my lord, what transpired, my lord, from the plaintiffs, my lord, I have referred to that paragraph, which say they have performed their part performance. Now it is me who is refusing to perform my part performance or reciprocal obligation. So their entire suit is based on, my lord, an agreement which has a reciprocal obligation and which is being performed partly. So, my lord, Supreme Court exactly says, if you make your ground of specific performance of part performance,
Yes.
then it's a sine qua non. It is not, my lord, simpliciter case that you have agreed to sell, I have agreed to purchase, he is not selling the property.
Supreme Court says something else, Mr. Chatterjee. Supreme
Hello.
Court says following postulates are sine qua non for basing a claim on section 53A. So if you have to have a claim on section 53A, then these are necessary, including a written agreement, because section 53A simply starts with in writing. So if there is no written agreement, you cannot have a claim based on section 53A.
No, my lord, yes, my lord, 16 is very clear that if a person files a suit, my lord, on the ground that the owners of the suit property has transferred on of them after agreement to sell and it was in pursuance of part performance. So, my lord, part performance is the, my lord, issue here. My lord, it's and 53A doesn't restrict itself only to transfer. There are other terms, performing of other terms as well. 53A, my lord, under the Transfer of Property Act, doesn't restrict itself to part possession. So, my lord, in case of part
But
performance,
it puts this as a defense, definitely, because it
but my lord,
says
Supreme Court says
that
even,
cannot enforce against the transferee.
my lord, that's why, my lord, unless I could have found this, I would not have argued it.
Obviously. But now you have found it, so we have also have to deal with it.
So that's exactly, my lord. Today, if it's even a, my lord, sword, not only a defense, it's a sine qua non. Now, my lord, once it is, my lord, upfront hold, my lord, then, my lord, the finding of the court on the Stamp Act comes into play after the Registration Act being amended.
If there is no written agreement, then they have not even pleaded any written agreement. So stamp is later.
No,
If this is upheld, then they don't have a case, in fact.
don't have to have a case.
But section 53 categorically says except what is provided in the agreement.
I understand. But now, my lord, this 16, my lord, is troubling me.
You don't know.
16 is troubling me. My lord,
Judgment is troubling us. 16 is troubling you. Yes, 16. 16 of the judgment, right? That's troubling us too. Very good.
now, my lord,
So we are
this was
paid
the
to be troubled. You are not. You are paid to give the trouble to the judge.
Yes.
But definitely, this is a valid, I mean, a relevant judgment. We'll have to consider. Yes.
Yes. Now, my lord, I rely upon 2025 law.
কথা বলে নেবো এটা। এটা নিয়ে একটু কথা বলবো। হয়ে যাবে।
judgment. No, no, সেকশনটা তো এত পরিষ্কার। Taken possession of the property. So there is only one thing.
Madam.
Please see section 53A.
53A.
Two elements are there.
Yes.
One is written contract
Yes.
and the other one is possession.
Yes.
Here, in this case, there is no written contract as well as there is no transfer of,
Yes.
handing over of possession,
Yes.
isn't it? And those are, conjunctive, not disjunctive.
And disturbing his lordship for a second, please come to para 16 of the judgment.
Yes.
In the instant case, absolutely that. And I add to that, in the instant case, respondent was 1 to filed an original suit for specific purpose of contract on the ground that owners of the suit probably transfer the entire possession of property to them after agreement.
Yes. And it was done in pursuance of part performance.
Not only part performance, here it was entire possession of. So part
Possession, yes.
performance itself is not the criterion as per the judgment also. Here property was, it was alleged that they had transferred the entire possession of property to them after agreement to same, and it was done in that context. Supreme Court holds that if that is, then their claim was based on 53A because it's agreement coupled with possession. Absolutely.
Now, my lord, yes, absolutely, my lord. So, my lord, as a suit, my lord, in part performance, this sine qua non comes in. My lord, my submission is this. If your suit is
But then for 53A to come in, there has to be an averment, the
of
allegation that
possession, my lord, kindly
coupled with
visualize
possession.
this. My lord,
that is the language of 53A.
my lord, if
also.
I take their oral agreement to be, my lord, there, my lord, then they say, my lord, 2014, those land which he has purchased from me in pursuance of that oral agreement, they are in possession of those other lands. Maybe not this land.
All right. No, but no, they are not.
Oral agreement is one.
They are not seeking specific performance of that part of the agreement. They are seeking specific performance of an agreement only focused on this property, this present suit property.
Yes.
This was not transferred to the rest, has already been transferred. The agreement has been spent.
Spent.
If there was an agreement.
If there was an agreement.
That is. So agreement has been exhausted. Regarding those, there is no cause of action in the suit.
Yes.
The cause of the suit, this suit is for specific performance of contract in respect of only this plot, regarding which there is no averment that any plot has been given.
My lord,
Rather, you
only-
take a defense that they don't have possession, therefore they can't have ingress in it.
My lord, only thing, my lord, I will just try to, my lord, distinguish this from the provision itself. The second part it is, and the transferee has in part performance of a taken possession of the property or any part thereof, or the transferee being already in possession, continues in possession, part performance of the contract, and has done some act in furtherance of a contract. So, my lord, there is other acts also contemplated in part performance. My lord, there are other acts contemplated in part performance, so not only, my lord, only possession. My lord, this cannot
But
be
it's premised on possession.
possession and some other act. So, my lord, it cannot happen possession only or some.
It's based on entirely on possession. See, where any person contracts to transfer for consideration by writing signed by him, etc. And
Yes.
the transferee has in part performance of the contract taken possession of the
Yes.
property or any part, or transferee being already in possession continues in possession in part performance of the contract,
My lord,
and has done some act in furtherance of the contract, and transferee has performed or is willing to perform his part of the contract.
yes. So, my lord,
All are and.
so, my lord, contract is one. So, in performance of a contract, he has to take of the suit property is not
In
relevant.
this Supreme Court judgment, the court held that there the plaintiffs were seeking specific performance on the averment
Yes,
that
yes,
transferred
yes,
entire property is
absolutely.
coupled with possession.
Absolutely. So, my lord,
And therefore, in that context, it was said that if you base your claim on 53,
This-
then they're not basing the moment they don't claim possession, Mr. Chatterjee, they're not basing their claim on possession.
yes,
Therefore, 53
I take
does
it.
not
My
come.
lord, I take it what is falling from my lord. So, therefore, my lord,
His lordship.
this, his lordship, my lord, this, so therefore, this judgment at least gives me a lens of support that it is in a case of a suit also, my lord, this sine qua non applies, not only in defense.
Yes.
Now, my lord, if that be so, my lord, today, the provision refers to performance of a contract. So, my lord, contract may have, my lord, possession of various lands. Maybe one of the land I am not giving to him. So, my lord, in this case, my lord, the contract includes various land of which they are in possession. So, my lord, it refers to one contract, not several contracts.
That's a bit far-fetched because they are seeking specific preference of in respect of vis-a-vis this plot, which they have not alleged to have, because the specific preference is not regarding the other.
Lord,
That may not be accepted by us. We take your argument.
yes,
Carry on. Yes,
Just to moving on to the next judgment, my lord.
yes,
Just to the earlier judgment, one part
yes,
of that judgment, paragraph 16. Lord, para 16, Roman 4.
Hmm.
My lord, kindly sees the transferee must in part performance account take possession of the property or any part thereof. So any part, my lord, in my kindly I add
the other.
other.
Sorry.
Now, my lord, moving on to the next judgment, which is of 2020, volume 5 SCC 410.
Yes,
Lord, paragraph 2, first line to show, my lord, this was a suit for declaration specific performance. Subject matter, my lord, relates to specific performance.
yes,
Now, my lord, kindly turns to paragraph 7 at the bottom without troubling with the entire paragraph.
Hmm.
In commercial dealings with high stake matters, delay is vital. My lord, relying on such and such, my lord, this was considered. Now, my lord, and my lord, this matter was also, my lord, based on, my lord, oral agreement.
Hmm.
That would be evident from paragraph 5. The last line. This is evident from alternative contention is that there exists an oral contract.
it's an alternative condition, but it was there.
It was there.
Yes,
Now, taking my lord to paragraph 15. Chapter 7, may I just place it here?
yes,
Chapter 7, Section 36 of the Specific Relief Act 1963 provides for grant of preventive relief. Section 37 provides that temporary injunction in a suit shall be regulated by the Code of Civil Procedure. The grant of relief in a suit for specific performance is itself a discretionary remedy. A plaintiff seeking temporary injunction in a suit for specific performance will therefore have to establish a strong prima facie case on the basis of undisputed facts. The conduct of the plaintiff will also be very relevant concern for the purpose of injunction. Similarly, in this case, an oral contract, undisputed fact, a strongest of the case. But in the present case, my lord, all the facts are disputed. My lord, there is always, my lord, either this way or that way.
Hmm.
Now, my lord, referring to paragraph 17.
yes,
The negotiations between the, I'm just placing this paragraph. The negotiations between the plaintiff and the defendant is reflected in approximately 17 emails exchanged between them commencing from December 17 to 31st March 2018. The file size of the attachment to the mails has varied from such and such, indicating suggestions and corrections from time to time. The WhatsApp messages, which are virtual verbal communications, are matter of evidence with regard to their meaning and its contents to be proved during trial by evidence in chief and cross-examination. The emails and WhatsApp messages will have to be read and understood cumulatively to decipher whether there was a concluded contract or not. The use of the word final draft in the email dated such and such cannot be determinative by itself. The email dated 26 February 2018 sent by the defendant at 11:46 am had also used the same phraseology. The plaintiff was well aware from the very inception that the defendant was negotiating for sale of the land simultaneously with two others. The plaintiff was further aware on that itself the deal with it had virtually fallen through as informed to the escrow agent. The fact that the draft MOU christened as final for discussion was sent the same day cannot lead to inference in isolation of a concluded contract. There is no evidence at this stage that the acceptance was communicated to the defendant before the letter entered into the deal with defendant number 2 on 30th March 2000 and executed a registered agreement for sale. Defendant number 2 paid such and such towards the income tax dues of the defendant the same day as part of the consideration amount. It is only thereafter the plaintiff purported to have communicated its acceptance to the defendant on 31st of March at 1:13 p.m. The prolonged negotiation between the parties reflect the matter was still at the embryo stage as observed in such a. plaintiff at this stage has failed to establish there was a mutuality between the parties, much less they were allied.
But here there was a written agreement in the sense that the emails can be taken.
No, my lord, it is only that draft MOU and the emails which were
Yes,
under the,
therefore, on the basis of those emails, the court came to the conclusion there was no concluded contract.
yes.
But Mr. Ray's client relies on oral agreement coupled with subsequent activities of the parties.
Yes, exactly, my lord, coupled with
But
activities.
here it was email is also considered email. Correspondence is also considered written.
My lord, I'm here correspondence is that 16 September. So
No,
he,
but correspondence does not constitute the agreement here. Here, according to this plaintiff's case, in your case, correspondence was a reiteration of the oral agreement
Lord,
which
it
is
was a,
already there.
yes. So, my lord, it was a case where, my lord, there were email exchanges. There also,
Here,
my
email
lord, court says
exchanges were the contract. The emails were the contract.
emails were the contract. So, my lord, court there also held that in isolation, one single email doesn't form a concluded contract. It has to be the strongest of the case. My lord, similarly here, my lord, when he refers to, my lord, reciprocal obligations, non-mentioning of anything on any of the documents, just mere assertion in plaint. My lord, it's my Rasul humble submission doesn't refer to any concludedness of contract. Now, my lord, paragraph 21 of this judgment refers to, my lord, an old decision of Supreme Court of Brijmohan, my lord. My lord is well aware of that, my lord. I refer to this, my lord, this because this Brijmohan, my lord, lends support to the Honorable Supreme Court suggesting that, my lord, the documents which were the most vital document to even show that there was some form of concludedness of contract are missing those statements. So therefore, court held, my lord, in case of oral agreement that cannot be done, and held there is no oral agreement. And my lord, finally, court refuses injunction here. Honorable Supreme Court. Now, my lord, that is 1990, volume 4 SCC, page 147. My lord, paragraph 2 kindly says this refers to performance of oral contract of this judgment. And has got, my lord, the first letter, 4 brothers who were brothers filed presence on July for specific performance of oral contract of sale. Paragraph 2.
Yes.
Now, my lord, paragraph 5, my lord, may I just place? It was further stated in the plaint that after the public notice was published in newspaper taking advantage of their wanton and deliberate act of evasion, defendant number 1 got a reply notice published in newspaper and got issued a legal notice dated such and such through her advocate, falsely alleging that there was no agreement for sale. Thereafter, plaintiff number 1 and 2 made sincere and repeated attempts to convince defendant number 1 that the fake and baseless pleas taken by their detrimental to the interest of all concerned, and there is existence of concluded contract of sale of the suit property, and the execution of the agreement of sale was a mere formality as well as the receipt of advance. Since defendant number 1 persisted in their illegal conduct, the plaintiff got issued a final notice dated 27 June 1970 calling upon the defendant number 1 to execute the agreement, receive the earnest money, and issue a valid receipt within 3 days of the receipt of the notice, thus giving defendant number 1 one more opportunity. The plaintiff never received any reply, nor defendant number 1 complied with the demands made in the notice. My lord, similar, we have not replied. Now, my lord, kindly takes paragraph 11. This is the summary findings of the trial court. I would just refer, my lord, the trial court's one line from the top 10 lines down. My lord will find reference to 2 exhibits. My lord, exhibit 1A and 1A2, A1, A2. And these terms were reduced in writing. So, my lord, they referred these exhibits to be reduced in writing. Now, my lord, on this exhibits, kindly takes up paragraph 16. The High Court further held that it must be remembered that this agreement is in respect of valuable property, and the main intention was to reduce the terms of agreement into writing, and then the parties are very much relying on the alleged oral agreement dated May 3rd, 1979, there would be definitely have been some reference in Exhibit A and Exhibit 2 to the oral agreement said to have taken place on May 3, 1979. The absence of the same in Exhibit A and Exhibit 2 again throws a serious doubt about the alleged agreement dated 3rd May 1979. In any event, the mere fact that there was a meeting between the plaintiff 1 and 2 and defendant number DW2 on May 3, 1979 does not establish that there was a concluded contract between the parties on that day, because admittedly defendant number was not present at that time. This is on full trial which is happening. Now, my lord, kindly paragraph 20.
Yes.
We have given our careful consideration to the arguments advanced by the learned counsel for the parties and have thoroughly perused the records. We agree with the contention of the learned counsel for the appellant to the extent that there is no requirement of law that an agreement or contract for sale of immovable property should only be in writing. However, in a case where plaintiffs come forward to seek a decree of specific performance of contract of sale of immovable property on the basis of an oral agreement alone, heavy burden lies on the plaintiff to prove that there was a conscientious addendum between the parties for a concluded oral agreement for sale of immovable property. Whether there was such a concluded oral or contract or not would be a question of fact to be determined in the facts and circumstances of each individual case. It has to be established by plaintiff that the vital and the fundamental terms of sale of immovable property were concluded between the parties orally, and a written agreement, if any, to be executed subsequently would be a formal agreement incorporating such uh, such terms which had already been settled and concluded in oral agreement. Now we shall examine, my lord, facts were examined, my lord. I'm skipping over. Paragraph 22 is relevant somewhat. It in the, my lord, page 161 of that judgment, my lord will find it is pertinent to mention 3 lines from the top. 4 lines. It is further pertinent to mention that. My lord has got that?
Yes.
It is further pertinent to mention that even in Exhibit 1A and Exhibit 2, which are the drafts of agreement for sale, there is no reference to oral agreement said to have taken place on 3rd May 1979. In case all the terms had already been concluded in oral, a contract between the parties on 3rd May 1971, and only a formal agreement was to be reduced in writing on 6th May 1979, then in that case, there ought to have been a mention in the draft agreement, Exhibit A1 and A2, regarding the oral agreement of May 3, 1979.
Yes.
According to the statement of Sri Bijmohan plaintiff himself, nothing was discussed with different such and such. My lord, I'm skipping over. Then, my lord, it was held, my lord, I'm not troubling and wasting time, that there was no oral agreement, it was found. So, my lord, exactly, my lord, he relies upon the reciprocal obligations. It doesn't refer to any oral agreement, not a slightest of indication, because these are the sheet anchors, my lord, of the documents, which could have presumably allowed the court to look into an oral agreement being in existence. So, my lord, being not there, my lord, today this strongest case is missing, and my lord, he is not entitled
And
to
heavy
it.
burden.
Heavy burden.
All right.
Now, my lord, wait a minute, 26 second. Lord, this is my lord's own judgment, my lord.
And there are better judgment side, some other.
I find it to be better for the moment.
Single judge.
No, my lord, sitting in division bench. Balaji, na 2026 SCC only. This is on the commercial aspect, my lord. But my lord.
What is the ratio of the judge?
The ratio is, my lord has held, my lord has suit which is of commercial nature. If it is found in regular civil court, the court lacks inherent jurisdiction.
Right.
Yes. My lord, this is 2026 SCC online, Calcutta 7582. 2020 SCC online, Calcutta 7528.
Then it's subject matter jurisdiction. It has to be inherent.
Yes.
So where have you heard that?
Well, my lord has held
26.
2026 SCC online, Calcutta. My lord will find it, my lord, in paragraph 48 onwards. In Patel such and such, Supreme Court was considering mandatory nature of Section 12 of Commercial Courts Act in proceeding which had already been instituted a commercial suit. In such context, it was observed that although the said provision was mandatory if the suit was prior to 28th of August 2022, that is the date of said judgment, the court would not reject the plaint outright. The said proposition was further developed in Dhanbad Fuels Private Limited, where the Supreme Court observed that a suit was instituted without complying with Section 12A prior to 20th August 2022 and suit in abeyance, and they referred the parties to time-bound mediation in accordance with the said section. If an objection is raised by the defendant by filing an application under Order 7 Rule 11 of the court, or in case where the parties express an intent to resolve the dispute by mediation instead of rejecting the plaint. There is no doubt that in the present case, both the suits were filed in the year 2020, that is before the cutoff
Come
date.
to para 53 directly.
Yes, 53 direct. Very. The Commercial Code Act came into force with effect from 31st December 2015. Thus, when the instant suits were filed in the year 2020, the Commercial Code Act was already in force. Hence, there is no scope of transfer of the said suit under Section 15 of the Commercial Code Act. The matter here pertains to lack of subject matter jurisdiction of the ordinary civil court, thus hitting at the root of the inherent jurisdiction of such court to entertain and adjudicate such suit. Unlike dearth of territorial or pecuniary jurisdiction, where the objection is that with regard to the taken at the first instance, rendering such objections waivable right. In case the court lacks inherent jurisdiction to adjudicate on the subject matter involved, there is no recourse left before the court to proceed with the suit. Since the very institution of such suit is without inherent jurisdiction ab initio, the said threshold defect cannot be cured merely by transferring the suit to the court having determination. So, my lord, I am on this. So, my lord, today, admittedly, it's a contract touching on the commercial industrial park. And my lord, today it happens to be a commercial suit.
Yes.
So, therefore, my lord, if it lacks inherent jurisdiction, I say, my lord, no court can pass any order. My lord, summing up, my lord, my case, there is no oral agreement, nothing of.
Yes.
But summing up, there is no oral agreement. There is no suggestive anything of oral agreement. Secondly, my lord, I have shown the prayers, my lord, that he prays for Indian egress to the source property, which cannot be allowed. Thirdly, my lord, he fails to make out any argument that we are obstructing. Fourthly, my lord, the argument, my lord, which my lord will definitely consider of the 53A. And my lord, lastly, my lord, commercial suit.
Thank you. Yes.
But I start with the map in CAN 3. Kindly take it up. My learned friend may not have been correctly instructed. I just indicate. Mapটা কত পাতায় জানো? Huh? CAN 3 তে ম্যাপটা পাবে। Hmm?
Okay.
Yes.
Yes.
Yes. But may I just indicate? But this entire land, which is in dotted lines, the entire part is mine. Out of this entire part, this in the middle, which my learned friend has shown, your lordship, is in two parts. Now, my lord, kindly see the first rectangle on the common passage. Yes. But I'm referring to this block.
Yes.
My lord, your lordship will see land of Devashish.
I. Written
I,
at
yes,
the
correct. I.
Yes.
Number this land of Devashish Pal 151.96 decimals. This is the suit property. This under construction JDA Hart, this is what he is constructing. Against which, your lordship will remember, there was a Bhumi Puja.
Yes.
Because of which I came to the court. Now, my lord, the straight line which shows 65.64 decimals, this is what I have sold him. And my lord, I will indicate that this gate your lordship sees, this is not my gate. This is his gate. My gate, my lord, is on NH6. From where, my lord, this 40 feet common road, common passage comes in. My gate is here.
At the bottom.
No, at the top. At the bottom. I'm sorry. Yes. At the bottom, my lord, to Kharagpur to Mumbai, National Highway 6. My gate is somewhere here. On NH6. This is
green
your
line.
gate.
এটা suit property gate তাহলে।
That suit property এইটা।
That green line.
That green line which is coming in, that is Malad the 40 feet wide common passage, which is coming in from NH6. Otherwise, Malad, from NH6, neither I can come into the property nor he can come into the property.
And on the left hand side, the gate under construction road, this gate belongs to him.
This gate under construction is his gate.
It's a suit plot.
Now, but your lordship will see where the gate is. The gate is on the 65 decimals of land. It is his land. It is not on the suit property. Why it is not on the suit property, I tell your lordship, because this 151 decimal of land has no access. This land of his 151 decimal has no access.
He has taken a foundational point, Mr. Rai, that till you have a specific preference, a decree, you don't have a right in that property. Presently, you have an
Correct.
actionable claim. So
Absolutely.
you have sought for injunction so that your ingress to that property.
No,
suit land,
no.
suit property.
But with greatest of respect to my learned friend, that is not my prayer. He is not reading the rest of the prayer. Kindly Mara, take the prayer of the injunction. Injunction ta kothai ache? Volume 1, page 143. A. An order of injunction restraining the parties respondent number 1 and 2, their men and agent servants, changing the nature and character of the suit property, making any construction thereon, and restricting free ingress and egress of the petitioner from the common entrance on National Highway 6 to the suit property, as also the plots of land owned by the petitioner. I don't want to enter his property. Kindly come back to the map.
Oh, so you say this to the suit property as also plots qualifies the common interest.
Yes.
On which you are asking for a field.
Yes, I am asking for an injunction restraining him from obstructing this road and also the left hand side.
Qualifies. So you seek an injunction regarding the common entrance on National Highway 6-2.
To the entire
This
property.
qualifies that common passage.
Yes.
So you are not seeking ingress and egress to the
No.
suit property, but to the common entrance, which also leads to the suit property.
Yes. That is my case. The entire
Wide road
property
and
it
the
has
narrow
to
road.
come. Yeah.
Both wide road and the narrow road.
Both wide road and narrow. ওই এটা দেখো ওই ডিডে যে ম্যাপটা ছিল ডিডের মধ্যে but if your lordship kindly comes to the page 63 of can 3, this is the deed. My learned friend has already placed parts of this deed. This is a deed where Devashish Pal is the vendor and I am the purchaser. Kindly see page 63. This is Malad. Kindly see the common passage here and then here and left. And this in between blank land is actually, Malad, if your lordship compares this 151 and 65. So this is the access that we have given to him. And why it is there, what he is telling me, Malad, kindly see, Lot B. And this Lot B, if your lordship compares with the other map at 89, your lordship will see it's a part of this existing building. So he gives me a part of this. If your lordship kindly comes back to 89,
Yes.
this land is just opposite the short common passage on the left hand side. It's a part of this building, which is existing building Regent International Hut B+G+4 is written there. That is Malad. So he gives me a part of this land and I give him that 65 and 64. If I don't give him that 65, 64, he does not have any access to the 151 decimals, which is the suit property. And my objection is that he is parking cars along this road and blocking my ingress and egress. Malad, page, my learned friend said that there is no evidence. I have given photographs. Your lordship kindly turns to one page only, 124. But possibly one continuous photographs. Just one I will show, page 124. These are trucks parked, right?
And there are several police complaints contemporaneous.
Construction.
সে ঠিক আছে
It was at the time of construction.
no this can I have filed long back. So that is my case. I don't want to enter on his land. I want to purchase his land. But he does not have. So, Malat, the prima facie case which I am trying to make out, your lordship will kindly appreciate this, Malat, is that if your lordship kindly looks at the map at page 89, what is the reciprocal obligation which I have completed? I have given him this 65 on Roman I or 1, and he has given me part on the plot which is on the right hand side of the common parcel.
That regent.
That is regent. Regent is my build. So, but the intention was, for whatever argument my learned friend has made insofar as the joint venture agreement, this, that is concerned, kindly look at it from the other point of view. The entire property is mine. There is only one plot in between which he is holding on to, which does not have any access from the main road. If your lordship does not look at that 65 decimals, which also he is entitled to, I mean, I am entitled to purchase from him, he does not have any access to this 151. This wood property, it is without any access. Why would somebody keep a plot of land which does not have access? If I had not given him the rights as per my deed in my common passage, which I had placed, I'm not troubling your lordship again, I had placed it at the time of my argument, then Malad, he could not even enter this plot of land. This is the factual position. Now, Malad, the next part, that his project is complete and he's running a hart, it's not on record. Either before the learned court below or before your lordship. It's not on record.
Subsequent event which has occurred.
But I have filed 3 cans. He has been served. No opposition.
On my lord's query, I have answered to that. This is
No
happening. He doesn't
opposition.
dispute that.
But I did not disturb my learned friend when
Subsequent bole bolchi dada, it is subsequent.
nothing on record to show that. I have filed 3 cans.
No opposition.
State or opposition. The other 2 cans are subsequent developments. These are subsequent developments in can 3. No affidavit. 4 cans. So no affidavit in the next 3 subsequent developments. Now, Malad, this is the factual aspect so far as the plots are concerned. Now, Malad, kindly consider he has placed.
Subject to correction, my lord, there is, my lord, indication of this in my opposition at page 9, bottom line.
Opposition to can 3.
Opposition to can 1. My lord, I have stated the fact remains as of date, the commercial project has come up, internal page 9 of the opposition.
Yes.
The last line of that paragraph, statement rather, the fact remains as of date, the commercial project has come up over the suit land and a constructed building is standing on and a hut is in operation on the ground floor. Affirmed on May 2026.
May 20. All right. Well. Now, Malad, then my learned friend's next argument is on the deeds, which were reciprocal agreement. But both the deeds are on the same day.
Yes, we saw that. 11th.
That's one.
November 15th.
Both are 1st November, registered on 5th November 2015. Now, his deed by which he is selling to me says agreed consideration. My learned friend has placed that before your lordship. So I agreed with him that I am going to pay him 1,46 lakhs. Agreed terms.
Yes, we saw that.
Yes. The other deed says maximum market value. I'll just place it before your lordship. So when I'm giving him money, it's in Okay, it says maximum market value. I'll just show it to your lordship. কোথায় দেখালো শুনি আমাকে? Internal page 9 মানে 10-3 page 53. Page 53 মানে the last line of the first paragraph, last two lines. Valuable consideration considering the price for selling, transferring, conveying as the highest available market price. So I am giving you at the highest available market price, and you are taking the agreed. I'm sorry, you are, this is the other way around. This is from you are the vendor, I am the purchaser, I am taking it from you at the highest price. And when I'm giving you at a lower price, and what is the land your lordship has seen? It's just 40 feet this side and 40 feet that side. So, my lord, I humbly submit what my learned friend again has been harping on, what the learned judge harped on in the lower court proceedings, is that we cannot find anything written. The oral agreement is not written in any document. It's not referred to any document. But my answer to that is these circumstances show on the same day exchanges are made, higher price, lower price. For you, it is agreed terms. For me, it is highest price. So, this is another circumstance which prima facie shows that there is an oral.
What is the difference in the areas of the two?
Same, 65 decimal, 65 decimal. Identical. Identical.
The mojas were different.
Yes, but that is because of that.
We ask the area. Yes.
But the right hand side is Mohiyari, right?
This is from the map itself, it's everything.
This side of the common passage is Mohiyari, that side of the common passage is Viponnapara.
40 feet.
40 feet. Now, my lord, the other argument which my learned friend made that is relating to the oral agreement. But there is no alteration of the oral agreement. In my respectful submission, your lordship kindly comes back to paragraph 4 of the plaint. My learned friend placed it and said that subsequently there is an alteration. But kindly come to page 13.
Yes.
A is the defendant number 1 owns 3.8680 acres land of land which is held as an undivided share as divided share. The defendant number 1 shall convey the total area of 3.8680 land to the plaintiff at an agreed consideration of 6.882217. That partition then sees that partitioned area of 151.46, which is the suit property. Now, Malad, he has already transferred part of it. That is there in my chart at page. Yes, at page 45, annexure C to my plaint.
Yes.
So, Malad, if your lordship sees, he says there is no deviation from the agreement. You have to sell me the entire land. Part of it you have already done. I get stuck at 151. So I come to the court. And that is evident from page 45, where I have given in 2014, you have sold me part of it. So there is no question because he did not refer to this, but your lordship will kindly note this, that he is to sell me the entire land. He has already sold me part of the land. When he refuses to sell me the next land, I come. My suit property is restricted to only 151. Because, Malad, if your lordship then moves on, after he gives me this 151, he will give me that 165 also. That is at page 15. It was also agreed between the parties that upon conveying the area of such and such in favor of the defendant number 1, the plaintiff would facilitate development and also provide this, that. It was also agreed that while conveying 657, the plaintiff would also use permit to enable him to ingress and egress. It was further agreed between the parties that the defendant number 1 shall convey his rights in respect of 65 decimals of land after all the conveyances and executed by the Pal family and other pro forma defendants' entire share in the land. So this 65 also he will sell.
That's why this page 82 letter is for.
That is why, but the page 82 letter refers to both 151 and 65. But my prayer in this suit is relating to 151 because first I have to get 151. I have to collect all the rest of it from the entire Pal family. Only then the last part 65 he will sell to me. Now after completion for that 65 also I could not have asked for specific performance of this because unless I finish all the part I cannot ask for the 65. 65 decimals, another suit is pending. I have got an injunction. And despite that injunction, he has constructed in part of the 65, which is order 39 rule 2 আছে তো? Order 39 rule 2 is also pending. And they have filed an appeal from the injunction order that is also pending before this honorable court. Very good. Next point. If your lordship kindly looks at the letter which my learned friend heavily replied, I only want to show page 82. That is at page 82. He has laid a lot of stress on the part of on the negotiation part at the last line. 3 places I will show. First paragraph is you have agreed to sell. First paragraph of 81 is you have agreed to sell. After this small paragraphs in part performance of our agreement.
Yes.
And then ultimately the next page, first paragraph, although according to our original agreement for sale. So 3 places I say it is an agreement. Only in the last paragraph I say commitment. So it becomes that there is no ad idem between the parties. There is no novation also from the plaintiff. The other point which my learned friend took, if your lordship sees
page 20, page 26, paragraph 27.
Yes.
You say reconstructed.
Yes. I have said reconstructed and that reconstruction is at paragraph 14.
Paragraph 14 also you have stated he will complete the full performance of
Yes.
the contract.
Yes. So he will, it was the agreement, original agreement was that he will sell me the original, the entire.
Paragraph 14 you say it is stated that defendant number 1 on 3rd of August 2017 agreed in the presence of well-wishers that he will complete and complete the full performance of the contract within 2 years.
So which includes both the lands. And that is why the letter also in 2016 which we send includes both the lands. That is not specific to only the suit property. But the judge, so far as the judgments are concerned,
Letter is silent on refusal.
letter is silent on refusal.
আমাকে বলেছি না যে they refused on the same.
Yes, limitation I so
Not
my
exactly,
letter friend
limitation
is not
delay.
delay. The delay part is if your lordship sees the sequence of facts, 2013 there was an agreement.
As per your cause of action paragraph 2016 it started.
Yes.
You filed the suit
Up to 2019.
You filed the suit in 2017 only.
No, 19.
2019. Sorry.
2019. Because why? Because of the Bhumi Puja. That is what I showed your lordship from the plain. Because he had committed that he will sell. I gave him a letter. But despite receipt of that letter, he did not respond, which amounts to refusal.
But why in your paragraph 29 you say, Mr. Rai,
Yes.
page 27, para 9, para 29,
Yes.
page 27 of the paper, the cause of action arose on 23rd September 2016 at the suit property when he refused to convey the suit property.
Yes, that is because of the letter. 23rd September
So then the
2016.
cause of action was the.
It starts from there.
It starts from there. You waited till Bhumi
No,
Puja and
because subsequently then he again committed that in 2017 that yes, I will do it within 2 years. That pleading is there. And up to 2018, I have purchased the other lands from the Pal family and the others. That chart is also annexed to the plan. What are the dates on which I have purchased from various parties? His part, because he is the defendant number one, I have given in a separate chart. The others, the entire chart I have given. Up to 2018, I have been acquiring. He had also referred to the development agreement. Development agreement says that I will contribute lands which will come in my hand, which includes his land. That's an agreement with a third party, or rather he is a third party to that agreement. So therefore, I need not mention that I have an oral agreement with Devashish Pal, that land will come in. I have another agreement with this person, that land will come in. I have kept it open that whatever lands what is already in my hand, I am giving, and whatever else I will acquire, I will put it in. But for that, I don't need to make separate agreements all the time. So far as the development part is concerned.
yes, now the judge.
Now, the judgments, 2018 judgment, is very clear. It is on section 53, both writing and in writing and possession. These are necessary. There is no question of possession. I am praying for specific performance of his agreement to sell the suit property. This suit is restricted to that. The agreement, of course, has various other terms and conditions. My suit is restricted to this. So, unless it is in writing and unless you give me possession of the suit property, the 2018 judgment refers to entire possession had been handed over. Here, there is no question of possession. I am admitting that it is his property. He is entitled to retain possession of the property unless I get a decree of the. So therefore, in my respectful submission, it doesn't apply.
Yes.
So far as 2020 is concerned, that is completely on different facts. You see 2020. Yeah, you can talk about
Emails.
emails. But so far as 1990 judgment is concerned, 90
Heavy burden, oral contract.
No, apart from that fact, 2020 judgment it is from a decree after trial. It refers to the exhibits. I am at a prima facie stage. I am asking for injunction, temporary injunction. So I am at the prima facie stage. That is a finding of the court upon trial. This matter has not yet gone to trial. I only have to prima facie show, yes, I have to show a strong case, definitely. But to the extent that whether there could be an oral contract or not, and if there is a oral contract, then what would be the balance of convenience and the irreparable injury? And so far as the Commercial Courts Act is concerned, the last judgment, I humbly submit, this is not a commercial suit. What is my prayer? Purchase of Shali land. All these lands were Shali land, and once I started purchasing, all have been converted subsequently. And my correct. So, I subsequently after purchase, even the deeds do not refer that I am going to build a industrial park there. No, development agreement comes later. My agreement is in 2013. My oral agreement is in 2013. I start purchasing. After acquiring substantial land, I make a development agreement at 2017. But that land was originally Shali land. So therefore, it does not come within the ambit of the Commercial Courts Act. Had it been, yes, I agree with my learned friend's submission. Had this suit been related to the development agreement, then maybe your lordship would have considered whether it's a case under the Commercial Act or not. But insofar as my case is simply sitter, I am purchasing land. But in that, my lord, in my respectful submission, Commercial Act will not apply. Yes, but it's simply sitter specific performance. And my lord, so far as the part performance or the specific performance is concerned, that comes from the 65 and 65 decimals exchange. That is the part performance, and the rest performance is 151, which I am claiming. Nothing more than that, nothing outside of that. Yes, but prayer, I have specifically not pleaded the oral agreement, but it is a decree of specific performance to transfer the suit property. And from the plaint, it is evident that it is based on the, just because the simple, I haven't said that the oral agreement dated such and such, executed between such and such, which the learned judge has also held, that what is the date, who were the parties, where you discussed, what was the place. So that will all come out in trial. But these are my subjects.
Go for it.
No, nothing.
Hearing is concluded. The matter is reserved for judgment. Thank you. The interim order was for a limited period.
No, but till disposal of the appeal. I'm great.
Thank you.
I am appealing for the appellant.
So the plaintiff respondent number 4
Right.
last दिन document
This is the matter, my lord. Probably your lordship has heard us. I will have to recapitulate for the benefit of my lord Justice Day.
Yes.
My lord, I am the defendant number 1 appellant before your lordship. My lord, plaintiff suit. Plaintiff is a flat owner in a multi-storied complex, which is my lord 36B. He claims a declaration in describing the schedule of the suit property, which is not conveyed to him by his conveyance. This is the moot point, my lord, which I had raised on the last occasion, my lord. Whether you can claim a what you are claiming a declaration in respect of a suit property, that must have been your property, undivided share must have been conveyed to you by the conveyance. So this is, if your lordship now takes, my lord, kindly the plaint and the description of the suit property in the plaint.
And they claim undivided share in that.
And they're claiming undivided.
Not easement right.
Not easement right. That your lordship that was your specific query, my lord.
Yes.
If your lordship kindly takes, my lord, the schedule to the plaint. Your lordship is taking up my FMAT 236. Lordship has made notes on the, because I had argued the FMAT 236. Probably it is item 4.
FMA 872.
It is page 82 of the stay application. The prayers are given.
Right.
FMA 872.
Kindly see, my lord, prayer A, decree for declaration that plaintiffs are having an undivided share or interest in the suit property. Lord, Lordship takes the schedule at page 84.
Driveway.
All that the driveway connecting premises number 36B and 37. I am in the middle, 36A. Along with central lawn within the project Fort Oasis situate at 36B and 37. In aggregate measuring 44,000 square feet. So therefore his conveyance must show as a common area he had been conveyed a driveway which is connecting his multi-storied building with another multi-storied building, that is 37, and a central lawn must be in his conveyance deed. Now this plaintiff has purchased from another flat owner. He is the second purchaser of that flat. And I will show your lordship that first deed. His vendor did not have, he does not have. Now, Lord kindly takes the first deed of conveyance. This is 28 September 2012. Starts at page 191.
Yes.
These purchaser at 193, Subhash Baheti and Urmila Baheti, they are the original owners of the flat. They have purchased from the developer of 36B. Lordship will kindly see a few recitals which will show, my lord. Kindly see. Lordship will see. So recital E at page 194. The purchaser companies with an intention to develop the premises entered into an agreement dated 26 July 2002 with Fort Project, hereinafter referred to the developer who developed the said premises by erecting structures as per plans sanctioned by the Kolkata Municipal. This is relating to 36B. Then, my lord, kindly see G 106. They have given a gift to the Kolkata Municipal Corporation as required, my lord. Then, my lord, H, in accordance with development agreement, developer applied for and obtained necessary approval permission for requisite that caused the building plan to be sanctioned, being numbered such and such, to erect complete buildings on the said premises. Your lordship will note that. On the said premises, hereinafter referred to a new comprising of various self-contained units. Then your lordship will come to K at 196. This is very important, my lord. Now, I will also rely upon the sanction plan which is referred to in this conveyance because it is part of a deed which is produced by the plaintiff. So that can be looked into for the prima facie stage. K is this. K is very important. Said premises, which is 36B, is contiguous to premises 37, 38, and 38/1, which is now renumbered as 37, admitted possession. It is contiguous, which is being developed by Fort Builder. So they have a common developer. His building and the another premises 37 is being developed by a common developer. And is also contiguous to municipal premises number 36A, with which I am concerned, which is presently under a lease for a period of 99 years with analytical management consultant referred to as AMC. Kindly note, my lord, conspicuously no interconnection between 36A, 36B, that is their premises, and 37, which is also being developed by the common developer, is mentioned. Separate plots, separate plan, separate building. Then, my lord, L.
Just no interconnection between 36A and
36A and presently numbered 37. At least recital K does not say so. Then, my lord, L. said Fort Builders and AMC, that is my client, are also undertaking development of their respective premises being contiguous to the said premises in pursuance an agreement dated 5th January 2006 entered into between owner developer Fort Builder and AMC, wherein it has been agreed that several of facilities which will remain common for all buildings to be constructed on the said properties, that is 36B, 37, 38 and 38(1), which is now 37, and 36A, belonging to the owners Fort Builders and AMC. This agreement has not seen the light of the day. Now this agreement has crystallized into a conveyance. Whatever has been agreed to by the developers of 3 premises must be given to you under this conveyance. If it is not so given, then you cannot rely upon an earlier agreement to which you were not a party. Now kindly see, my lord, the developer has completed construction of the new building at the new premises, already obtained completion certificate. Why I am relying on this is just to show that there is no interconnection between his premises and another 37, because that is his schedule to the plaint. There is a motorable road connecting both these 2 premises. Now kindly see, my lord, O. Purchaser being desirous of acquiring a flat stock unit on ownership basis approach the owner vendor for the same. Upon discussion, purchaser agreed to purchase and acquire flat number such and such on 9th floor. Kindly note this, my lord, building block number 6. So there is more than one building in 36B. Of the said building containing measuring such an area with car parking space together with 197. Together, this is very important, together with proportionate share or interest in all common parts or portions and areas and facilities, and together with undivided proportionate share in the land comprised in said premises attributable thereto described in 2nd schedule. So, my lord, what he has got is the flat proportionate undivided share in the common areas described in the second schedule.
So it's intra 36B.
Yes, intra 36B. Now, my lord, instead of placing everything else, let us come to, my lord, 198. This is the main part of the deed, what has been given to him. To have and hold, sorry, my lord, just above that 197 at the bottom, my lord.
Yes.
After describing his flat, last 8 lines from the bottom, together with undivided proportionate share in the land comprised in the premises attribute more fully described in 2nd schedule, together with right to use and enjoy in common with the owners and occupiers of other units at spaces at the building complex. That is 36B. The common parts, areas and facilities more fully described in the 3rd schedule. So 2nd and 3rd is what he has got, undivided share. So, my lord, let me straight away show your lordship the schedule to this deed. Kindly come to 205. This is the first schedule, first.
Yes.
This is the description of 36B. It is showing, my lord, north, east, west, south, everything. No interconnection. Then, my lord, 2nd schedule is what he has got absolutely. That is flat on the 9th floor at the building known as 06. There are more than 1 buildings in 36B. Then, my lord, kindly see, 3rd schedule is very important. Common areas and facilities mentioned in this deed shall include. All these your lordship will find that the usual common areas which are there: underground water, community hall, children playing area, health club, swimming pool, roof, water body, playground, marble flooring. So, my lord, there is no conferment of right, no existence of any motorable road. So, my lord, this your lordship will compare with the schedule to the plaint. This, my lord, there is nothing what is there in the schedule matches with the third schedule, in which he has an undivided share undisputed.
Although third schedule says shall include, inclusive,
Yes,
but page 197 it stated uh, as if it means more fully described in third schedule.
third schedule. Not something else other than this.
And at best, on the last occasion, you pointed out also that they are saying lawn. So page 206 F and K, children playing area and playground, but they have described this as lawn,
Lawn.
not a children's
Yes.
playing area.
Now, this is their predecessor's deed.
Yes.
Now, same thing your lordship will get in their deed also, which they have purchased later, my lord. That is your lord. That is at page 131. The schedule, my lord. Starts at 108. First schedule is same, 36B.
132 is important.
Yes, 132, my lord. Again, here also building block named and known as 06. Not a standalone building. Now, here, my lord, kindly see third schedule. What my learned friend on the last occasion tried to say is, kindly see third schedule A. Driveways is there in third schedule A. Driveway is within 36B. It is not a driveway connecting another premises, which is there in the schedule. This is number one, my lord.
This is inside
Then-
36B.
36B, within 36B, because there are 6 buildings. So this third schedule is the same as his predecessor's third schedule. And whatever is there in the schedule of the plaint is not in his third schedule. This is my first and foremost submission, my lord. Now, your lordship will kindly take a few paragraphs of the plaint on which the learned judge has exercised jurisdiction to grant an injunction. Hmm? देखो। Kindly take, my lord, page 70, page 74. After coach title, it starts, my lord. Paragraph 2, your lordship will see. This was placed by my learned friend, and I also placed it. Project Fort Oasis has been constructed by Fort Group. The defendants herein are all part of Fort Group. This is their case. Defendant number 3 to 20 are landowners of 36B, where he has the flat. Defendant number 2 is the owner of adjoining premises 37. Previously 37, 38, 38 by 1. Defendant number 1 is the long-term lessee of premises 36A. Separate premises.
You are defendant number 1.
I am defendant number 1 of 36A. Then, my lord, kindly see paragraph 3. He has said how he has acquired the flat that conveyance have shown, your lordship. He has purchased from these Bahetis on 24th December. Now, kindly see paragraph 4, my lord. It is very important. This is contrary to his schedule of the plaintiff. Kindly see, he says, plaintiff state all aforesaid 3 premises are contiguous to each other. Fort Group, through the defendants, had conceived project Fort Oasis as a larger project comprising 36B and 37. I am out. 36A is kept out. As part of such project, it was agreed between the defendants herein the central lawn with motorable road connecting premises number 36B and 37 would be constructed and would remain part of common areas and facilities of project Fort Oasis. So, this case which is trying to make out, unfortunately, his vendor or their vendor did not give it to him in the conveyance. And, my lord, I will rely upon the sanction plan of their premises to show that there is no motorable road which is connecting another premises, which is 37, which has been developed by a common developer under separate plan. Then, my lord, kindly see paragraph 5. He's saying that on such representation that there will be a motorable road connecting, flats have been sold at the project Fort Oasis by Fort Group to several flat buyers, in which includes the plaintiff and her predecessor in interest. So that developer is not a party. He claims, therefore, that I have purchased or my vendor have purchased on the basis of this representation. They are not parties. So this is a cause of action which is against them. The aforesaid agreement for sale dated such and such, indenture of conveyance dated 28th September.
Shall we continue
Yes,
after the recess?
yes.
May I only one suggestion? May I only mention that in the morning I came to the mention that time the list was called on.
No, no, no.
Is there a date fixed on 100?
I was placing this paragraph of the plaint.
Yes. Para 4 you have placed.
Yes, para 4 I've placed. Not from there it appears that they have pleaded that 36B and 37 is part of a larger project.
Yes.
Though it is not appearing from the conveyance, I'm only saying what is their case. I am still out. 36A is still out of that so-called fourth project, fourth Oasis. So, now kindly see para 6. And para 5 is that on that representation, they had purchased flat. Para 6 says, aforesaid agreement for sale dated 23rd September 2009 and conveyance dated 28th September 2012. This is their predecessor's conveyance. Also clearly record and confirm that such central lawn and motorable road connecting 36B and 37 are part of the common areas, facilities and amenities of the project, more fully mentioned and described in schedule written hereunder. So this is a representation given to court is that the schedule which we have described is part of the common area and it is a connecting between two premises, which is contrary to a deed which they have relied upon in the plaint. So the court will have to go by the deed rather than by this averment. Undivided proportionate share or interest in the common area, including the suit property, has been duly conveyed and transferred by the fourth group. I only accept that whatever is the common area described in the conveyance has been conveyed to them, and schedule described does not form part of that. So if I am asking for declaration of something which is not in my conveyance, that is the basic argument, my lord, which I want to make, my lord. Then, my lord, paragraph 7.
Here also 36A is absent.
Absent. Whatever they are claiming is that interconnection between 36B and 37. Nowhere I am coming in between. It is on the basis of the aforesaid that two main gates for ingress and egress of the project has been constructed, one each on two ends of the project, located at entrance of 36B and 37. Residents of the project used both the gates of ingress and egress in order to use the same in the manner. The central lawn and motorable road created at the project is essential. Such possession continued without any obstruction since the year 2012 when the two gates and the motorable road have been in operation. Lord, I will rely in this connection the sanction plan of their premises, which is referred to in the conveyance. You copy, Judge.
Part of the trial court records.
It is part of the conveyance. Conveyance refers to this plan. So I am not going beyond the conveyance.
I am not aware.
Was it not there before the trial court?
Conveyance was there.
Maybe an incomplete document, conveyance, maybe an incomplete conveyance.
If it's referred to in the plaint, then the conveyance
Not
will refer
referred to in the
Conveyance,
conveyance is part of the plaint, but the conveyance does not have this document annexed to it.
and it is numbered. The plan number is also mentioned in the conveyance. I just want to show that this tallies with the description in the conveyance.
Does the deed, their deed, mention about the sanction plan anywhere?
Yes.
Let us see that
Yes, yes,
part of
but
the deed
I
first,
did-
then we'll look at it.
Yes, it definitely. I showed one recital. I'll just come to that. Yes, kindly come to 195. Their deed also does. This is their predecessor's deed. Recital H. In accordance with the development agreement dated such and such, the developer applied for and obtained necessary approval permission from the requisite authorities and also caused the building plan to be sanctioned by the authorities, being sanction number such and such dated 25th of May 2000, whereby and whereunder it became entitled to.
This was not a part of the deed.
No, it is referred to in the deed. Not part of the deed, but it is referred to in the deed.
Then it's not even secondary, it's tertiary. I mean, referred to in the deed, some document which is referred to in the plan we can look into. Sanction plan was not a part of the deed, it will be going a bit too far.
Very well. It doesn't matter, my lord. I just
Definitely.
thought, my lord, kindly thereafter, my lord, come to the next part. Paragraph 8, my lord, kindly see. While the plaintiffs and other residents of the project continue to enjoy the central lawn and motorable road without any interruption and or disturbance, plaintiffs found that a new building was being constructed at 36A, that is my portion, being the portion of property held by defendant number 1 under a long-term lease. The defendant number 1 maintained a tin shed and bamboo boundary around the said premises, with the main road on one side and other 3 sides of the existing project photoasis. It was learned that an independent building is being constructed within the boundary wall of 36A, within boundary wall of 36A, without any connection with the existing project. However, this is one of what is important. However, it was recently learned by the plaintiff that the defendant number 1 was proposing to encroach into the motorable road and the central lawn of the project oasis. Question of encroachment will arise if I am owner and in possession of a certain property. This so-called motorable road and central lawn is absent from the deed itself, whether it is the first schedule or the third schedule. Because even if it is not a common area, but it is part of 36B, then within the first schedule description, it should be there. That there is a motorable road and a central lawn existence. So, my lord, this case of encroachment completely goes in view of the conveyance which is relied upon. Then, my lord, paragraph 11. Kindly see, reference is now made finally to this so-called agreement of 5th January 2006 to cling on to some sort of a right. What is that? By virtue of the arrangement between the defendants and the fact that instrument that were executed on defendants and on basis thereof conveyance which have been executed in favor of the flat buyers, motorable road and central lawn are part of common area and facilities. So they want the court to read into the conveyance motorable road and central lawn, which they say is not there, but it is part of a so-called agreement of January 2006. Now, my submission is January 2006 stands superseded by the final deed of conveyance. If it was there in the January 2006, but you have not got it ultimately in the conveyance, you have a separate cause of action against the person who did not give you that. But it cannot be read into the conveyance. I am not a confirming party to your conveyance. I don't know, Lord, what is this 5th January 2. You are not even a party to that 5th January 2006. You have not produced the 5th January 2006 before the court. But you want the court to read 5th January 2006 into your ultimate conveyance deed. Now, my lord, interestingly, I am not placing the rest. What happened? The association filed a consumer complaint before the NCDRC. They have pleaded that.
Their association.
Their association.
Their buildings association.
Yes, their flat owners association. There, my lord, we had filed a reply raising the maintainability of the complaint on 13th of May, and the suit has been filed on 15th of May, and the interim order is 16th of May. But this is, I think, all, my lord, which I need to show your lordship, because this now is the case which they are trying to make out is a case of encroachment. And paragraph 15, your lordships will see, that is their main arguable case. On about 7th May, it was found that area around the new construction being undertaken by defendant number 1 was being cleaned up from the work undertaken it has become evident defendants, particularly defendant number 1, is in the process of shifting its boundary wall by encroaching upon the suit property again. So, my lord, it is a case of cause of action is of encroachment. So, if it is of encroachment, you first prove, my lord, that prima facie show that you are the owner and in possession and have a right in respect of that part.
26 থেকে discussion চলছে। 2024 তার আগে
Paragraph 17, your lordship will see, even otherwise, suit property being the central lawn and motorable road are in possession of the project Fort Oasis being within its boundary wall for more than 14 years. This is contrary to the deed. So, my lord, this is the structure of the plaint, my lord. Now, my lord, let us directly come to the order impugned, my lord. What is the rationale for passing the nature of injunction which has been passed, my lord? Plaint. দেখেছিলাম তো প্রথমেই দেখেছি। The order number 2, 16th of May. But it is in the stay petition also, page 231. Because this is in the first appeal.
Yes, this is against an extension of that.
Extension of that.
Page 261.
231.
230. Yeah.
Kindly see, my lord, first, after plaintiffs claimed the plaintiffs are owners of residential flat on such and such block 6, Fort Oasis at premises number 36B. Kindly note thereafter, together with car parking space and several other rights at 37 and also 36A Ponditia Road. They have not claimed any right in 36A Ponditia Road or even in 37. Then, my lord, Ford Group through the defendant has conceived the project as a larger project comprised of 36B and 37, not my property, my lord. It was agreed between the defendants that central lawn with motorable road connecting premises 36B and 37 would be constructed, would remain part of the common areas for such purpose. The agreement of 5th January. Well, I need not place anything else there. Let us come, my lord, next page. Page number 2, on May 9, 2026, when the defendants made clear that their intention is to continue with possession, altering the boundary line, thereby encroaching the thus no part of the cause of action is barred by limitation. In order to prove, well, this is very important, to prove the contention of the plaintiffs, they have produced deed of conveyance of 2020, agreement of sale of 2009, deed of conveyance of 28 September 2012. Now, my lord, now kindly see, considering the entire facts.
What is the photographic records evidencing long-standing use?
Photographic records.
Photographs have must have.
This is the photograph, my lord, which they have annexed. So that map, my lord, which we have also produced, that the Google map, satellite map. Those are part of the petition at page 220. This only shows, my lord, the Fort Oasis project, 37 and 36B, and my property is in between. But I had given to your lordship this kind of a map on the last occasion to see, my lord, the demarcation of the premises.
These were given to us.
Yes.
These photos were given by them.
No, these were given by them.
By them.
These are the or whatever copies
Origins of those.
This one.
I have prepared a set with the page numbers, my lord. Your
This one.
lordship can return this. I will hand over when my turn comes with the page numbers corresponding to the.
Thank you very much. We have got that also. These ones.
Yes, yes.
What was part of the record is part of that colored. which I have
This
handed.
your lordship can keep. This is colored boundary indicated.
No, we have this colored one also.
Oh, wait. 36B, my lord, your lordship will see, and 36A, middle and right portion is 37.
This is the boundary of the defunct train.
Yes.
And this green line on the top, which is coming here, this is part of 36A. There is a separate deed of lease by corporation in favor of my client.
Which
This
is the
is-
suit property?
This green.
The suit property, my lord, which they are trying to say
Which color?
should be part of this red.
The thick red.
Yes.
This one.
Yes, which is according to them connecting this left side 36B with 37.
All right.
So this was acquired in 2009, post 2000.
Yes. 8%.
And this drain portion, my lord, we had acquired after that so-called agreement of 2006.
Drain is the bottom of the L.
This top, my lord,
To the
full.
attach.
This your lordship will get even in the schedule, first schedule which they described in their conveyance.
This should be this part of the red line.
Yes.
Between the two premises.
Yes.
Yes.
The existence of the drain, your lordship will get even in their conveyance deed in the first schedule. That is bounded by the drain. So, but if I come back to the order, so the
Where is the main road? I mean, over the drain. It's a covered drain.
it's a covered drain.
Defunct train. It's a defunct train.
It's a defunct drain. That portion has now been leased out to us.
So where is the main road from where you have access to it?
This is
Above.
Ponditia Road. Dekhan
Furniture.
Yeah,
Below.
bottom, my lord.
Bottom.
Kindly see
Yes.
Ponditia Road.
Yes.
Defunct train.
Hmm.
The train. This is the train. We acquired in 2009. The lease date is enclosed with the stay application. Google map, which I had shown,
Drain is the entire green portion.
Google map, which I had.
This is the suit property. Blue
This
mark.
is the suit property. Panditya Road is on the right. It's mentioned there, Panditya Road. Towards the right of the suit property. And the two entrance gates are on the where one is written Tridhara and the other where it's written Fort Clubhouse, Fort Oasis Clubhouse. These are the two entrance gates of the property.
This was the train. Rail.
Judgment cited.
Blue, according to us, is that road.
Both the property.
blue which we-
Blue is the
So, my lord, if your lordship sees, court has relied upon the conveyance deed. 3 deeds of conveyance have been relied upon. Then it starts. The finding is considering the facts and weighing the balance of convenience. I am of the view that the plaintiff has made out a good prima facie case for trial. If the court has considered the conveyance deed, then, my lord, where is the even one single line that the suit property is included in the conveyance deed? Now, my lord, I just show one judgment on the aspect that the 5th January 2006 agreement is part of the recital of the conveyance. But the main body of the conveyance deed, what is conveyed, that is described by Schedule 2 and Schedule 3.
5th January agreement is mentioned in the conveyance deed. There.
Yes, in the recital, not in the operative part. I'll show your lordship, my lord, where it is
You
mentioned.
let us see that first.
Yes, I shall show your
Because
lordship.
obviously, Mr. Thakkar will be relying
No,
on
but
that.
I also, my lord,
Yes, therefore,
kindly see. Yes, যেকোনো একটা detail দেখো।
that 195, page 195, that
190 is
195 is a part of 4th page of the deed. In
Yes.
that deed, it is contained.
yes.
Somewhere. Just look.
Kindly
at
come to recital L at 196. 196.
Yes. Oh, yes. You also showed that. right?
Yes. Port builder,
While showing this, you argued that this was not a part of
part of the
ultimately
my lord, where
merged into this.
yes. And kindly also see what is the subject matter of this. It only says it has been agreed that several of the facilities will remain common for all buildings to be constructed on the said properties belonging to owners, Fort Builders and AMC. How will your lordship get what is the subject matter of this agreement? What are the facilities which are to be given common? that there is a motorable road which is to remain common. So nothing is there.
AMC, you are AMC.
I mean,
So you are a party to that agreement.
yes, as per this agreement. But I am not a party to this conveyance. I am not a conforming party. I need not be, because nothing of my property is being given to them. So once your lordship reads recital L, your
That
lordship,
5th January agreement was also produced by them.
no, it is not produced. It is not produced. That is why I say that the court did not have the occasion to see what are the facilities which were agreed to remain common under the 5th January agreement.
Disputed property was acquired in 2009.
Well, I can still therefore argue
Hmm.
that whatever common facilities have been conveyed in the 3rd schedule to this conveyance deed is the subject matter of 5th January
That
2006.
merger argument remains, I mean, supersession argument
Remains.
197 টা দেখে দিন, what was the annual impact converted?
And my lord, in respect of page 197, which is the main transfer portion under the conveyance
Does
deed,
not count.
this is not there.
Agreement is not mentioned.
Agreement is not mentioned. It only mentions common parts, areas, facilities more fully described in 3rd schedule here under written. So, my lord, therefore, my lord, I just want to rely on this to say that recitals will not control the operative part of the deed. And this is AIR 67 Calcutta 119. এটা দাও। সেলাই করা নেই তো। And kindly just give me leave, but it is not stitched at the
Stapled.
staple.
Give it to us later. Okay.
Here, my lord, 8 terms of a bond
Hmm.
was under consideration. Kindly come to paragraph 8.
Yes.
Contents of the aforesaid paragraph 2 and 3 stated to be the recitals, and those in paragraph 4 being the operative part have caused the trouble. The contention of the plaintiff respondent, which weighed with the learned subordinate judge, was that the security was for all future liabilities either of himself or of his subordinates, but not for the past acts or defaults of himself or his subordinates. It was a safeguard only for all future conduct. According to the plaintiffs as well as the learned subordinate judge, expression in the recital portions may come and may from time to time in paragraph 2, and the expression may in any way suffer, sustain, or pay by reason of the misconduct, neglect, etc. in paragraph 3 of the bond refer only to the future transaction, not to the past. The expression in the middle of paragraph 4 in the operative part of the document to the effect and shall also at all times indemnify and save harmless the government from is controlled by the said provisions in para 2 and 3. Now, thereafter, your lordship will straight away come to paragraph 13. The recital, introductory or general, or what has been illustrated by the Scotch term narrative, which should be inserted in an instrument with great caution, may be looked at in order to ascertain the intention of the parties, and often highly important for that purpose. Whereas the words in the operative part of the instrument are clear, they should not be controlled by the words of recital. Recitals, though subordinate to the operative part, are sometimes relied upon to prove the facts mentioned herein, but no inflexible rule can be laid as to the proper weight which are entitled in all cases. Reciting part of a deed is not necessary part in law, though it may be made use of to explain doubt of the intention of the parties if there be any. Then, my lord, paragraph 15. The recitals do not, in my view, possess an influence of their own on the solution of the question in their favor. They either become ineffective as words of indemnity or must in construction be read with the operative clause, or ignored or regarded as struck out of the clause of indemnity. Then, my lord, your lordship will kindly see paragraph 19. Justice S.K. Das, in delivering the judgment of the Supreme Court in the case of such and such, and in dealing with the interpretation, of course, applicable to the grants observed at page 902. If the intention is obvious, a fair and liberal interpretation must be given to the grant to enable it to take effect. And the operative part, if plainly expressed, may take effect notwithstanding qualification in the recital. Justice Subba Rao, in delivering the judgment of the court in the case of such and such, observed in paragraph 5 of the said report at page 9. Therefore, whatever ambiguity there might be in the recital, that was dispelled by the unambiguous declaration made by the parties that the property was given as security for the loan and the document was executed at mortgage. Justice Gajendra Gadkar, in the case of such and such, observed, in our opinion, it would be unreasonable to construe these recitals by themselves apart from other recitals in the document. Then, my lord, paragraph 21 also. Support of this contention cites the decision of the case of such and such in order to establish that the extent of the condition of the indemnity bond would be restrained by the recitals, though the words of the condition import a larger liability than the recitals contemplate. The principle in my judgment is inapplicable in the present case. Chief Justice Mansfield noted, and therefore coupling with the whole with the recital, it appears that the clear meaning of the parties that the defendant should become surety only for the consequence of the past transaction. The learned judge further observed the next way that there is not a single word that in its proper signification relates to future transactions. That is not the case here. The language of clause 4 in the present agreement is clear enough. It refers to past as well as to future transactions. Document confines in unambiguous terms the executants to agree. It would be a fallacy to say that the language is ambiguous. There is no ambiguity. The only ambiguity in the operative part, if there be any, is one which is suggested by the recitals. That is not an ambiguity which will induce us to give the operative part as it stands any other than its natural meaning. So, my lord, I rely on this for that purpose. But in any event, my lord, the final deed is the conveyance deed. And my argument will be one of supersession.
If there is no ambiguity in the operative part, then
Yes.
recital that will prevail over the recital. That is the proportion.
Yes.
No material. In paragraph 30, 32, no material. সেটা হচ্ছে আপনার সীমা শান্তি দেয়
ব্লুম ফিল্ডটা ছিল না একটা
হ্যাঁ আছে আছে
ওটাই একবার দেখুন I just want to rely on one judgment of 2025.
You don't mind her asking Mr. Shin, is she your relative? No.
Junior.
She resembles Justice Shamul Sen somewhat. That's why you asked. Don't mind her asking. Yes, please carry on.
2025 1 SCC 741. This is only on the principle of appellate
Yes.
court's power in respect of grant of injunction by the court below.
Any particular paragraph? If
Yes, just one. Paragraph 11. Order of the learned trial judge does not discuss even cursorily the prima facie strength of the plaintiff's case.
Paragraph 11.
Paragraph 11.
Starts with undoubtedly.
Huh?
This is Bloomberg.
Oh, well, I have a different copy. Well, I'll just.
Oh, achha, you just please repeat what it starts with. The
The
order of the learned trial judge.
in view of
The order of the order of the trial judge.
Para 10 in our copy. Yes.
Para 10, yes.
Does not discuss
Yes,
even
well,
cursorily.
the order of the trial judge does not discuss even cursorily the prima facie strength of the plaintiff's case, nor does it deal with the balance of convenience or irreparable hardship that is caused. The trial judge needed to have analyzed why such an ex parte injunction was essential after setting out the factual basis and the contentions of the respondent made before the learned trial judge. Trial judge merely states in para 78 that the court has gone through the record available as on date and noticed certain precedents where an administrative injunction without even cursorily dwelling on the merits of the plain, the administrative injunction granted by trial judge amounts to unreasoned censorship which cannot be countenanced. Undoubtedly, grant of an interim injunction is an exercise of discretionary power, and the appellate court, in this case the High Court, will usually not interfere with the grant of interim relief. However, in a line of precedent, this court has held that the appellate courts must interfere with the grant of interim relief if the discretion has been exercised arbitrarily, capriciously, perversely, or where the court has ignored the settled principles of regulating the grant or refusal of injunction. The grant of an ex parte injunction by way of the unreasoned order definitely falls within the above formulation, necessitating the interference by the High Court. This being a case of injunction granted in defamation proceeding on a media platform, impact of injunction on constitutionally protected right. Next, my lord, 13. In view of the High Court ought to have, in our view, also at least prima facie assessed whether the test for grant of an injunction was duly established after an evaluation of facts. The same error which has been committed by the trial judge has been perpetrated single judge of the High Court. Merely recording a prima facie case exists, balance of convenience is in favor of the grantor, and that would not amount to application of mind to the facts of the case. Threefold test cannot merely be recorded as a mantra without looking at facts. So this is what, my lord, I say, that you are relying upon the conveyance deed, but there is no discussion that the suit property is conveyed. I think, my lord, these are my submissions. Well, your lordship will the order, my lord, kindly be vacated, and
no order. There is no reason. No reason at all.
there is no reason in my respectful submission also, my lord. Narration of facts followed by reference to the documents produced, and then, my lord, the order has been passed.
Great.
These are my submissions.
Yes, Peter.
I filed the suit on the apprehension that the defendant number 1, that is Mr. Sen's client, would encroach.
You are the plaintiff respondent number 1.
Yes, please, my lord.
Thank you. Please continue.
I went to court on the apprehension, and in fact, on the not only apprehension, but on their overt act and conduct that they would encroach upon the motorable road and the lawn being adjacent to the motorable road. That is my cause of action, which I have pleaded. In the memorandum of appeal, which is filed here, it is admitted that I am in possession of that land and that I have encroached upon that land. So my possession is there. That is admitted in the memorandum of appeal. Kindly have the memorandum of appeal.
In the suit on the suit property?
Yes. Kindly have the memorandum of appeal.
But memorandum is not supported by an affidavit, Mr.
The stay application has no, the stay application has the same paragraph.
Stay application shows from the stay application. Otherwise, you will be technically, I mean, we'll
No, I follow.
rely on it.
But nowadays, my lord, we cut, copy, paste, my lord, it's
No, not that.
the learned judge Erdin. Kindly come to. Paragraph 25 at the bottom of page 23, please. The learned judge, in passing ex parte ad interim order and further extending the same, has failed to appreciate that it is only part of the defunct drain leased out to the appellant in the year 2009 and illegally encroached upon.
Your Fort Oasis is a part of this, your
It's my
premises,
building.
37.
36A and 37 are Fort Oasis.
Right.
36A and 37 are Fort Oasis.
No,
I'm sorry, 36B and he is
Yeah.
36. I'm sorry.
Right.
36B and 37 are part of Fort Oasis.
I'll just
Now he says
Yes,
that
yes.
it has been illegally encroached upon. So I am in possession. Right, wrong, that is for the to be decided in the hearing of the suit. I join issue with the fact.
But in their favor, this is a submission. But still, it's a submission made before the court.
It's a submission made before.
Affirmed as a submission, not a fact. But still, had to be a submission if it's a copy paste from the memo.
Yes. So the verification
They
is
could not have stated this.
It's
That
an-
would be maybe, I mean,
no. If they had, it's actually a
it's
matter
a
of
submission
fact,
made
but
before
it's
the
a
court.
submission.
It's a
made-
stand taken before this
So
court.
stand taken before court. So I am in possession. So this possession has been protected. by the order impugned.
Hmm.
I have come to court with a case that I am in possession. He is seeking to encroach.
Have you claimed possession? You have not claimed
I
possession.
have specifically, kindly, I have claimed possession since past more than 14 years.
Show us
Kindly
that
come to
paragraph.
paragraph 17 at page 80.
Page
80, please, my lord.
80.
Yes. Paragraphs.
17 years. Yes, yes.
Paragraph.
No, you're in
Even
possession of
otherwise, the suit,
Fort Oasis.
yes, are in possession, being within its boundary wall for more than 14 years, uninterruptedly, openly, and clearly, with the knowledge of the defendants.
Hmm.
And this is now proved to be correct. Now, the order which is impugned is an order directing status quo to be maintained till the rival rights and title of the parties is determined. Now, my lord, it's the entire argument. So this is on why the status quo order is perfectly justified on their own showing. Because your lordships have held order 39 prima facie case and not prima facie title. Now, my prima facie case, I am in possession. I am being sought to be dispossessed. He says I am encroacher. This is a perfectly triable issue which the suit will decide. And here the rights are to be preserved as they are for the ultimate determination. Now, the entire argument proceeds on the basis, my lord, that this suit property is part of his premises.
No, he says it's somewhere in between the two premises.
I
Not a part. He does not say that it's a part of his.
So if it's not a part of his premises, if it's no man's land,
But you are the plaintiff, you have to show a right to the property.
I will show from my conveyance. My learned friend has placed parts of my conveyance. But today, my lords, if he does not say it is part of his premises, then with the greatest of respect, he cannot seek vacating of the interim order.
All right.
Then he's not a party aggrieved. I go and get an injunction on a third party land, which is, or a no man's land, let us put it that way, taking his case to the highest, then he can't be a party aggrieved. And today, my lords, we are restricted to what is stated in the plaint, with the greatest of respect. So any submissions made asserting any right title or independent right title of interest of any nature whatsoever cannot be countenanced at this stage. If he sets up a rival title, then it cannot be set up at this stage for the first time. It has to be first adjudicated upon by order 39 rule 4 or whatever it is. So possession admitted, possession asserted by me, admitted by him.
But then if you look into this, this is also beyond the trial court.
Which one, Manoj?
You have to look at your plaint only.
If your lordship, no, your lordship
plaint says you are in possession of.
My plaint says I'm in possession, but your lordship can see his application for stay. Your lordship can definitely see his averment.
This is the premise on which he
comes to court. Yes, your lordship will not see any contention or document which he relies on to establish his own case. But here, so that is, I can always hold him to an admission here. Now, Milad, so if he is today not able to even venture to make an argument that he is the owner of the suit property, then he cannot claim to be a party aggrieved to come up in appeal. So he has to he takes my plain case, he shows your lordship's paragraphs of my plain case and my predecessors, the mother deed, if I may say it that way, the mother deed to show that no right could have come to me because my predecessor in interest never had it. That is the long and short of his argument as I have understood. My plain case is, and which remains uncontroverted today, is paragraph 2. That he is a part of the fourth group of companies. Can you see paragraph 2, which I had placed on the last occasion?
Yes.
Project Fort Oasis has been constructed by Fort Group. The defendants herein are all part of Fort Group. The defendant number 3 to 20 are the owners. Defendant number 2 is 37A. Now kindly see, he is described as defendant number 1, long-term lessee of premises number so and so. So all the constituents of the fourth group hold this larger parcel of land which is comprised in these municipal premises. That is my specific case. Now that this case is not incorrect, is actually borne out from my conveyance, or rather my mother deed. It will be borne out from the mother deed itself. Because your lordships will today see, your lordships are testing on a preponderance of probability is as to whether the case which I have made out is correct or not. Kindly have the mother deed once, please, which starts at page 191 is the mother deed of the Bahetis from whom I acquired. Now kindly have.
This is by this your vendor acquired, right?
Yes, please. This is the first transfer from the owners and developer,
Right.
the first sale agreement of the flat in question. I am the subsequent purchaser.
Yes.
Kindly have page 196, please. Kindly have K. The said premises is contiguous to municipal premises number 37, 38 and 38-1, Panditya Road, which is being developed by Fort Builders, hereinafter referred to as Fort Builders, and is also contiguous to municipal premises number 36A. This 37 series became, my lord, 37, 38, 38 by 1. Subsequently, I became 37. 36A is the appellant before your lordship.
Yes.
Which is presently under lease of a period of 99 years with AMC, the appellant. Then kindly see L. Said Fort Builders and AMC are also undertaking development of their respective premises and being contiguous to the said premises in pursuance an agreement dated 5th January 2006 entered into between the owners developers, that is my owner developer, Fort Builder, that is 37, and AMC, that is 36A, wherein it has been agreed that several of the facilities hereinafter referred to as the facilities will remain common for all the buildings to be constructed on these premises. So all the municipal premises. Now, of course, this is a recital. This is not the habendum. This is the recital. So the recital is, and then your lordship sees all the premises belonging to owners, Fort Builders and AMC respectively. So the deed has this representation that these owners of all these premises have entered into this agreement. I am not party and I don't have a copy of this document. I am not supposed to have because it is their document within the group. Now kindly come to the recitals. Kindly have page 204. Now this is the, I'm sorry, the habendum, not the recital, the habendum. Kindly see U. Terms, conditions. Lordships have that.
Yes.
My lords have terms, conditions, clauses, schedules, and other obligation and rights of the aforesaid agreement for sale dated so and so shall apply herein. This is a conveyance which was preceded by an agreement for sale. That agreement for sale is a registered document, reference of which your lordships will get. It is annexed to the plaint also, which is referenced in this deed is at page 197. It was a registered document. Signed and executed formal agreement for sale. Your lordships have that. This is the agreement for sale which is referred to in the habendum clause U. The conveyance is preceded by an agreement for sale as is usual, my lord, in these transactions. This is, so this 23rd September 2009 is the document which is referred to in 197 that forms part of the lower court record, trial court records. But what this conveyance says importantly is it incorporates by clause U.
Yes.
Terms, conditions, clauses, schedules and other obligations and rights. So it by specific, it's an incorporation by reference. Specific. The document from which it is to be incorporated is mentioned. What is to be incorporated is also mentioned. And kindly note, my lord, clauses and schedules are all deemed to be part of this. Then, my lords, kindly see Habendum
Very
V.
broad. Terms, conditions, clauses,
Yes.
schedules, and other obligations.
And other obligations, practically incorporating the entire document. But
Yes.
I only beseech your lordship to say that the clauses and schedules are specifically, it's in the arbitration jurisprudence, there's something that you can refer to a document, but not the arbitration clause, and the clause doesn't come in.
Yes.
But I'm showing you I'm covered.
Even in certain statutes also, land statutes and other statutes, this incorporation by reference.
Is
How
there.
far is incorporated the entire statute or anyway?
But I don't have much occasion.
No, you didn't.
Kindly see V now, please.
Yes.
Purchaser is aware. Now kindly see, this is now the
That
recital.
agreement was produced in the trial court.
Beg your pardon?
Agreement was produced in the trial court.
It's part of the records here itself. It's here. But I'll come to that present.
For effect. You're
No, I'm showing that why I rely on, because otherwise it will be said the agreement for sale stands superseded by the conveyance.
yes, yes. That
Or
has been
merged,
said.
it merged in the conveyance. That's what means.
Yes, maybe.
Now, my
No, but
kindly
the U is there. U is clear.
U is very clear. Then kindly see V also, please, my lord.
Yes.
What was there in the recital is also part of the habendum. Purchaser is aware of the fact that the said premises is contiguous to municipal premises number 37, which is by fort, contiguous to 36A, lease of AMC. Vendor has purchased and are required to right the develop. Kindly see. Vendor has purchased and or acquired the right to develop other premises contiguous to the premises as aforesaid, and is in the process of developing the said premises as part of the present project. When, kindly note the words, that is why I said group. Vendor has purchased and or acquired the right to develop other premises contiguous to the premises as aforesaid. These are the other premises which are contiguous to my project. The vendor has acquired, because they're all part of one group, and is in the process of developing the said premises as a part of the present project. Said premises being 37, my lord, and 36A. This is premises number 36B. Then may I read further, my lord? Consequently, as a result of this, consequently, certain facilities and or common, kindly note, my lord, areas or portions shall be common to all the premises, including 36A, the appellant, 37, and or the newly acquired premises as a single project, and shall be used as such, and the purchaser shall not object to or have any objection to the same. So not only do I have a right, but I will not oppose the occupants or create any impediments in the occupation of these common areas by the occupants of 37 as well as 36A. So this is now habendum. Now kindly have the agreement for sale of 23rd September 2009, please, my lord. Starts at page 159. This is the agreement for sale. Kindly see recital L at the bottom of page 163, please. This is the common thread in the documents. Kindly see L. Fort Builders AMC. Fort Builders is developing 37. AMC is going to develop 36. Your lordships have 163.
Yes, yes.
Page L, clause L at the bottom.
Yes, yes.
Fort Builders and AMC are also undertaking development of the respective premises and being contiguous to the said premises in pursuance and agreement dated so and so entered into with all these parties, wherein it has been agreed that several of the facilities hereinafter referred to as the facility will remain common for all the buildings to be constructed on these premises. Now, at the stage of trial, your lordships would be aware, when all these all the three entities, my developers, the owners, Mr. Sen's client, the owner of 37A, the developer, they are all party defendants. The law gives me certain rights to seek this document of December. So today, my lords, it's not that I am in possession of this document. I'm not party to this document, rightly said by Mr. Sen. I'm not party to this document. But my agreement proceeds on the basis that you are drawing some rights from this document. And you are also fettered with an obligation that this is in common with everybody else. You will not claim exclusive rights. Now kindly come to, please, my lords, page 174, Article 8. All this now forms part of my mother deed. Recreation center, your lordships. The owners, developers, along with the lessee or developer of municipal premises number 36A and 38/1 Panditya. So 38/1 is now 37. Have agreed amongst themselves to provide some of the facilities which is to remain common for all the owners and or occupiers of the various flats, units, apartments forming part of the said building, that is my building, as well as the building and or buildings to be constructed at premises number 36B, 36A and 38/1 as more particularly described in 7th schedule.
Difficulties, these common facilities, some others, several others, it's
Beg
rather
your pardon,
vague.
Miss?
Everywhere. I mean, even in the earlier clause, it's very vague in the sense that several of the facilities will remain common.
Yes, Malak, there's something called, it refers to a 7th schedule here, 8.1.
Yes, yes.
So 8.1 says recreation, it's style recreation, but it says these are common facilities or facilities which are all described in the 7th schedule. 7th schedule, your lordships.
We're rushing towards the 7th.
Hey, 183. I'm not able to keep speed, Malak.
No.
183.
Please.
183, please. 7th schedule.
Right.
Such facilities, kindly see, such facilities which were provided under the said tripartite agreement. This is the famous or infamous January agreement. Executed between the seller along with the owners, sellers of 36A and 36B, which shall remain common for all the owners and your occupiers of the various flats in all the premises, and are as follows. Now kindly see 95. The owners, developers, along with the owners, lessees of municipal premises number 36A and 38/1 had formed a club to provide the various facilities in common in premises 36A, 36B and 37. I read 38/1 as 37. At the premises number 36A, that is Mr. Sen's client, a tennis court and a lawn shall be provided. This is for which my association has gone to the consumer forum. Then, Malad, kindly see, I'm not troubling you with community center. Now, kindly see 36B, community center shall be provided at 36B. That is my part. But they will use this. Then, lounge, drawing room, now kindly see 5, please.
5 is very important.
All passages and common paths will remain common and for common use between the owners and occupiers of the various flats, units forming part of the said building, as well as the buildings to be constructed at 37, 36A and 36B.
Said building is?
Said building, my lord, is actually 36B. Said building is the building which is now being sold. 36B has more than one building, Mr. Sen told your lordship.
All right.
So all the buildings comprised in 36B, all the buildings to be constructed on 37 and 36A. Said building is the building in which the individual flat is. Any other part or portion which may form part of the said building, as well as the buildings to be constructed at 38/1, 36, 30B, which may be necessary. Kindly see 6. I'm sorry, Malin. Which may be necessary for the common use and enjoyment. Occupiers of the various at the said building, as well as the buildings to be constructed at such premises. Then 7 is very important, Malin. All the above mentioned facilities and such other facilities which may be provided by the seller along with other owners 36A and 1 so and so shall remain common for all the owners and occupiers of the various flats forming part of the said building as well as the building and or buildings to be constructed at 36A and 36B. All three premises throughout. Then state says I'll have to bear proportionate charges along with what may be levied by for use of the facilities of 36 and 37. 9. I will have to abide by their rules also. So this, my lord, can only be possible if they are one group or if, which is my plaint case, they come together to develop this larger plot of land which is comprised in different municipal premises. Now, it is said that my documents don't show. With the greatest of respect, my documents clearly show. And even if the suit property is alleged to be in 36A, my conveyance gives this a right. Today, this document is there. He has not filed a suit. This document dates back to, my lord, 2009.
At the page 204, the incorporation reference,
yes,
that was a part of your vendor's deed.
Yes, my mother did.
But is it reflected somehow in your deed also?
It is not reflected. I only get what my vendor has.
You may not get whatever your vendor had.
I get whatever my vendor has. With the greater, he does not reserve any right. I cannot get more than him.
Can get less than him.
Well, with respect,
Depending
perhaps
on the deed. I may have the entire High Court as my property. I may sell one of the rooms to you.
Correct. Now, what
you
is
cannot have more than the High Court.
I
but
follow,
you may
madam.
have less.
What is sold is the unit along with all its appurtenances. These are rights which run with the unit.
All right.
It's not as if a part of a building is being sold.
Let's come to the relevant portion of your deed once to rule out that aspect of the matter. Your deed is...
My deed also has these recitals. Kindly come to my deed starts at 108, please.
Yes, yes.
Kindly have 117. Has this and whereas at the bottom of the
yes.
This is it has to.
Why are you so?
No, my lord. I've marked it, but is that? But again, it will be said this is part of recital and not addendum. That
No. Once you say that, I mean,
yes,
we have to see a link between your vendor's deed and deeds.
But it's not that the vendor has reserved any right. It's not, it can't be contended today, at least at this stage, that the Bahitis have reserved any right, although they've sold the unit.
We'll have to go at the first instance, the most proximate document is your deed.
Yes.
Because you are relying on your deed to claim whatever there is.
I am relying on this entire, on my chain deeds also. These chain deeds are also, that's how I've acquired title. Kindly see, Malad.
No, your right is conferred by your deed in the first place.
Yes.
Then we look at the chain deeds. So if there is any reference even, then you have a prima facie case.
This is the references there.
This is one.
Yes. Malad, I would also kindly take it kindly don't take me amiss, but if I argue the other way, if my conveyance, if my conveyance had something which my vendors did not have, if my conveyance has something which my vendors did not have, it would not come to me.
No, but the converse may not be true.
Converse, my lord, in a fact situation like this,
vendor had may not come to you. He may reserve some right and give whatever is there in your deed.
Yes.
We have to go by that to ascertain what you have.
Very well, my lord. It shows
because
the clear reference.
Sell less than what
clear reference to that.
May reserve the right in that common passage. We don't know. I mean,
my lord, may reserve. So that reservation has to be here.
No,
that
I may be the owner of 2 buildings.
Yes, please.
I sell only one to you or one room of the
I follow, my lord. I follow, my lord.
So I need not write in my deed in your favor that I am reserving in my favor.
No, need not.
But we have to go by whatever is given to you in your deed. So let us see the reference.
So, my lord, why I say this, slight difference here is these are, my lord, facilities which run with the unit.
All right.
For the enjoyment of this particular unit.
That's the difficulty, Mr. Thakur, because we are being confronted with from the beginning. We were looking for it, but you have not claimed easement rights. You have claimed undivided interest and title in the property.
My lord, I claim undivided
interest. Where we are, because therefore we have to go strictly by your deed.
I bow down. So now,
if it was a case of easement of necessity, then it would be much easier for you in that sense.
I bow down, my lord. I have claimed a right of ownership, a lot of which will turn on the this agreement of December? What is the right which these landowners or the
You are satisfied up to your vendor. Let us suppose proceed from there. Let us see something to indicate in your deed that those were given to you. Let us see what was given. Let us come to start with 117 for starters. Let us begin
Yes.
with 117.
117? Yes, please, my lords.
Code builders are also.
Then kindly see 118 refers to my mother deed and the conveyance. I'm sorry, refers to the agreement for sale. Then refers to the conveyance. The next this is the conveyance, my mother, and then it comes to second schedule. Bhayati is paid taxes, etc., etc. Undivided half share. One 122.
Yes, your best.
At 124.
Yes, 124 refers to second schedule.
Yes.
If you come to the second schedule at page 132, the end of the second schedule, the last two words, last phrase, and facilities and together with the undivided proportionate share in the land comprised in the said premises attributable there. Because otherwise it's and also yes, you may be correct in saying
kindly
it's all common parts and portion areas and facilities.
It's of the widest import, my lord, and with
Yes.
respect, my lord, the mother deed pertained only to this unit, did not have any other unit. The
Mother deed referred to this unit.
This unit only. And what is now being transferred is the absolute interest of the vendors in that unit. It's not as if the vendors retain anything. It's something which is running with the unit, if I may put it that way.
Everything falls back upon second schedule.
Yes.
So let's one see it. It's very clear, second schedule. Residential flat being the unit containing such and such. It refers to together with proportionate share or interest in all common parts, portions.
It does, my lord.
Together with the undivided proportionate share in the land comprised in the said premises, attributable thereto is very wide.
Yes. And my lord, 124 also, my lord, if your lordship sees the recital also.
Yes.
And the addendum, sorry.
Yes.
Because now these witnesses.
Together with right to enjoy.
Yes, together with right to use and enjoy in common spaces at the building complex and the common paths more fully described in the share and all manner of former and other rights, privileges, easement and benefits whatsoever belonging or in any way appertaining there.
That appertained there.
Yes. Or usually held or enjoyed therewith.
Former and other rights.
And reputed to belong to or appertain thereto. These are, my lord, the Moga on conveyance as well. So whatever my vendor had, my lord, which includes that schedule in the 7th schedule in the agreement.
Just because you had not gone through this deed, you are shying away from.
Had not.
This is better than even the previous deed.
Yes. Now, my lord, what weighed with the learned trial court is also the photographs. Kindly have the photographs once, please, my lord. I have kindly ignore that set which was there given because it didn't have the page numbers. I have got them numbered now, my lord. The other side के लिए ये किसके लिए ना मेरा कहाँ है many copies are there ना पेज नंबर गलत हो रहा है तुम्हारा 220 220 my lord in blue shows what is the suit property. Now
yes,
this is the clubhouse which is referred to here, my lord. This is in my premises 36B clubhouse. Your lordship remembers in the conveyance in my agreement for sale.
Where is clubhouse written?
It's written there, my lord. Fort Oasis Clubhouse, just at the tail of, if your lordship sees.
Oh, yes, yes, sorry.
Yes, so this is part of 36B. That agreement for sale had. Clubhouse will be at 36B. Now, this is the road which leads to Fort Oasis at the top, my lord, your lordship sees.
Yes.
This is that 37. And now if your lordship sees what is my suit property, the motorable road connecting 36B and 37. This is the suit premises which I have claimed. And the two entries to this entire project are, one is next to, it's not identifiable here, your lordship, it's on the right hand side next to Fort Clubhouse on Panditya Road is one entrance, and one is where Tridhara complex is written. That Tridhara community, whatever is there.
Yes.
Now kindly turn over to page 222, please, my lords.
Yes.
This is the motorable road which is in existence. And your lordship sees the under construction building which is being constructed on 36A. This is the road abutting.
This cobbled sort of this one.
This cobbled, yes, paved road.
Paved.
I'm sorry, no, paved road.
No, you describe it as a driveway.
Motorable road.
Lawn, you also.
No, lawn is next to it. I'm coming to the lawn.
All right.
So this is, your lordship only makes a note of this structure which is coming up.
Yes, yes.
That is the building under construction. Now kindly
That
see
is
this.
whose building?
His
Their
building.
building.
Yes,
Your building.
his building. Then kindly see 223.
Yes.
Now, your lordship sees his boundary wall which is there. It's a brick built boundary wall. It's not a temporary structure. It's not a tin shed which is put up at this time of construction. This boundary wall has always been there. His construction is coming up inside the boundary wall. And this is the motorable road which I am referring to, which is connecting. My building is towards where the Kolkata, West Bengal is written, in the background of that. And the towers which your lordship sees behind the bushes is 37. Behind the bushes, that's the lawn which I'll show your lordship presently. But the towers are the 37 which this road is leading to. Because the residents of the towers will come and use the clubhouse at my premises. That is why it's provided. And I will use the ingress for the gates over there for ingress and egress on Panditya. This will become more clear from 224. Kindly see, there's not even a gate there. It's a free open road.
In between 36B and 37.
Yes, 36B and 37. And his boundary wall is already there. Now he wants to break his boundary wall, come into this. And that is the status quo which has been held. So this is the established status as on date. Then this is the lawn. Kindly see 225.
Inside that tin wall.
Yes, the tin wall is the extension of this barricades the road from the lawn, basically. This is not the tin wall of the construction. And your lordship will see the towers behind.
So this is the tin wall at page 224. Rather the barricade at 224.
Yes. It separates the lawn
The
from the
inside,
road.
That was from the outside.
Separates the lawn from the garden. But Malad, it's not contiguous with his premises. The clear demarcation. Then kindly see, Malad, 226 is the same. 227 makes it even more clear. This is from the other end.
Yes.
And this, he says, is non-existent. I'll show your lordship his submission. He says this is a non-existent fictitious motorable road. He says this is a defunct drain. Maybe a drain.
Left hand side is theirs.
Left hand side is theirs. 228, they've zoomed in to show the width.
Yes.
229 is the lawn with the tower behind. 230 is just nothing else. So this is the status of the suit property at present. What is now sought to be done is encroach upon the suit property when I am admittedly in possession. That is why now, if your lordship sees the other paragraphs now, my lord, in the plaint, if your lordship will kindly have a look at. And this is the photographs that your lordship inquired. What was the photographs the learned court has considered? These are the photographs.
Photographic evidence.
Photographic evidence, yes. Now, my lords have seen paragraph 2.
Yes.
Then kindly see paragraph 4, please, my lord. The plaintiffs state that all the aforesaid 3 premises are contiguous to each other. The fourth group, which is the paragraph 4, please, my lord, of the plaint at page 75. The plaintiffs state that all the aforesaid three premises are contiguous to each other. The fourth group, through the defendants, had conceived the project Fort Oasis as a larger project comprising premises number 36B and 37. As part of such project, it was, now kindly read Fort Group in conjunction with paragraph 2, includes all the defendants. Fort Oasis is 36B and 37, but it has this motorable road in between because AMC is also part of the Fort Group. As part of such project, it was agreed, kindly see, it was agreed between the defendants herein that central lawn with motorable road connecting premises number 36B and 37 would be constructed and would remain part of the common facilities and amenities of the project Fort Oasis. For such purpose, the agreement was. This is established A from the deeds and B from the photographs. His premises is outside, it has a clear boundary wall which does not come into this motorable road. Then kindly see, on such representation and by virtue of creation of such common facilities and amenities, flats have been sold at the said project Fort Oasis by the Fort Group, which includes the plaintiff. So the group was Fort Group, its project was shown to your lordship, but it is Fort Group which includes them. Now kindly see 7, please, madam. Paragraph page 76. It is on the basis of the aforesaid that two main gates for ingress and egress of the project have been constructed, one each on the two ends of the project located at the entrance of 36B and 37 Panditya Road. 37 are the towers. So one end is that side, one end is this side, and there is the road in between.
Yes.
The residents of the project used both the gates for ingress and egress, and in order to use the same in the manner, the central lawn and the motorable road is essential. Such position has continued without any obstruction since the year 2012, when the two gates and the motorable road have been in operation. This is my clear case. We are now in 26. If there was anything in my deed of my the mother deed, if I may say, is a registered document. A registered document is, the person is deemed to have knowledge of that document. If anything in the registered document was contrary to Mr. Sen's rights, should have been
Notice under the transfer property.
Yes, and he should have had it delivered up and cancelled. He need not seek a declaration. I'm sorry, he should just seek a declaration. Does not need delivery up and cancel because he's not party. But this deed is there since 2012. The road has been there prior thereto. There's no suit.
Now, Mr. Thakur, another question to you. All said and done, yes. Suppose you have your rights over by all are common facilities and as if right of user, not undivided share. From because suppose we look at page 163, page 204.
I follow.
163.
Lordships is reading on the basis of the papers today that my prayer A may not stand. But that is
it may stand regarding the they're not
prayer B. That is prayer B. They have no
non-transfer of the property. That is part of prayer A. Not
A is my lord decree for declaration that
no. We are speaking about the injunction application.
I'm sorry, injunction. I'm sorry.
Yes.
Can you give me?
No, that is also your right. That is also
Respondents from encroaching prayer is nothing to do with it. It's only to maintain possession today, my lord. I'm not seeking any.
Yes.
This injunction is limited to my lord possession. And then if he constructs, develops, it will be irreparable damage till the suit is decided.
Yes, that goes with the other.
Yes, so the road on which I admittedly have access and I have possession, according to them, I have encroached upon this road. If that now kindly prima facie case is established on his own showing and from the photographs, there is a road which is in use. My case in the plaintiff is used since 2012. His case which he comes to your lordships with that I am wrongfully encroaching. And now, my lord, kindly see the balance of convenience and injury. If he is allowed to construct on this road and the suit succeeds, and I am deprived of the use of this road till the trial of the suit, which I have been using uninterruptedly since. So that is balance of convenience and irreparable injury today, my lords. Can't be compensated in monetary terms. Now, my lord, two more paragraphs of the plaint, my lord.
Yes.
So 7 I've shown your lordships, my lord. Can we see 16 now, please, my lord? The defendants, particularly defendant number 1, has been found to be taking steps to shift the boundary wall and encroach upon the suit property. 16 at page 80. The defendants are taking steps to, now your lordship sees the construction and the short boundary wall, if I may call it. That is what is being sought to be shifted. It's not even a temporary tin structure. That boundary wall has been there demarcating his property since the project has been finalized and erected. Then
said both common areas, undivided share or interest in the common areas, facilities and amenities.
Yes.
Very
And
good.
17, my lord, even otherwise the suit property being the central lawn and motorable road are in possession of the project Fort Oasis, that is comprising 36, the two buildings, 36 B and 37, being within its boundary wall. Now kindly see, his property is outside the boundary wall. The photograph said, this suit property is within my boundary wall. For more than 14 years, uninterruptedly, openly and clearly, with the knowledge of the defendants in each one of them, and there has been no objection to the same till the time mentioned herein before. So whatever I have stated in the plaint, your lordships will not believe it to be true and correct. Your lordships will find it is actually true and correct. It's borne out from the photographs themselves. And 23 says suit property is situated at all these three premises. But today, my lord, the limited nature of injunction is that do not disturb the possession which is there. Do not disturb the nature, character and possession of the property, which he is now seeking to do, till he establishes his right, whether in joint with me or exclusive. Possession cannot be grabbed. Right? Even if I take it to the highest that I'm a trespasser, let me take my case to the high to my lowest. I'm sorry. His case to the highest, I'm a trespasser.
Yes.
He says I'm an encroacher.
Without due process of law.
I can-
Trespasser is not entitled to injunction is a true owner, which he is not.
Against the
True owner.
true owner.
He's not claiming to be the true owner of
He's
that
not-
property.
Yeah, he cannot at this stage. At this stage, he cannot. My lord, this is something which has to be adjudicated upon. And more importantly, my lord, this agreement, if the agreement comes before court, which it ultimately will at trial, might show that they have divided among themselves that all these rights will go. They will
So
be
the
held.
agreement for your vendor's sale, that itself incorporates everything
It
there,
incorporates everything.
which is made a
Part of the mother deed. All rights under the mother deed flow to me. One decision, my lord, has been cited as to why your lordship should interfere. That's a larger bench, but that was in the context of a suit for defamation.
Yes, defamation. We saw
I
that.
have a
Bloomberg.
fairly recent, but of a smaller, lesser bench strength. But I think the principles are analyzed here more elaborately. Kindly have, my lord, here the trial court had granted an injunction, the appeal court interfered with it. And then paragraph 19 onwards, please, your lordship. Principles are the same, my lord, flows from Wander and Talks. Paragraph 20 is noticed. Then kindly see 22.
Now, what is it? It's a memory game, Mr. Thakur. You quote the previous judgment, which quotes the previous
Yes.
judgment, and it goes on.
Now this considers the English decisions.
Because this paragraph, it will make our judgment look better.
But
Whichever way
paragraph-
we hold.
One judgment can be read, my lord, so we can read all the others.
Paragraph 26.
That was the fun of Justice S.B. Sinha.
SB Sinha, sir. Yes.
Now,
But this I pulled this out. I wanted to show this because old decisions of our court have been noticed with approval, including Mukta Kesi.
Mukta Kesi, it has gone up to that.
Yes. And beyond Mukta Kesi. Kindly come to 26 once, please, my lord.
Not
Once-
Israel versus Shamsher.
Beg your pardon? No, 26. Kindly see 26 once. Principles of law explained by this court have been reiterated in a number of subsequent. However, over a period of time, after analyzing some decisions, the test laid down by this court as regards the scope of interference has been made more stringent. The emphasis now is more on perversity rather than a mere error of fact or law in the order granting injunction pending the final adjudication of the suit. This is a high test, my lord, which is now. Then other decisions are noticed. Sham Sale, my lord. Then just one line of Sham Sale, my lord, which is there. It is further observed that the appellate court itself decides the matters required to be decided by the trial court. There would be no necessity to have the hierarchy of courts. Then 31, appellate court in appeal, these are fairly well settled, is only required to adjudicate the validity of such order, applying the well-settled principles of order 43. Then temporary injunction, prime of, can you see 33 once, please, my lord? The burden is on the plaintiff by evidence, aliende by affidavit or otherwise to prove there's a prima facie case in his favor which needs adjudication at the trial. The existence of the prima facie right and infraction of the enjoyment of his property or the right is a condition precedent for the grant of temporary. Prima facie case is not to be confused with prima facie title, which has to be established.
I record to read this.
No. Perverse is then defined, and just kindly have where Mukta Kesi is considered.
Anything new in the edition?
Nothing new, my lord. Paragraph 45.
That would be of interest.
Paragraph 45. Promoter Nath, my lord. Mukta Kesi is in fact 44. That is the rule laid down in Mukta Kesi that lis pendens is not an answer to refuse injunction.
That part was upheld, but the other part was upset by the Supreme Court. Justice aim
reasons.
Reasons, yes. Justice aim Bhattacharya's division.
Yes.
Bhattacharya's division.
Now, my lord, which is the subject matter of reference. And then 45 is a 1901 decision of our court, which is preserve property in status quo during any pendency of a suit in which the rights to it are to be decided. This was a case of course, transfer. But Tagore law lectures, everything has been noticed fairly. So, that is all that this trial court has done, my lord. It has preserved status quo, directed status quo as on date to be preserved. And my lord, just Mr. Haq says, my lord, the trial court has been persuaded to pass this order. Just unless it is perverse, my lord, reasons are there, may not satisfy your lordship's test, but if reasons are there and it is not said to be perverse, then I would beseech your lordships not to. Oh, this is the extension order. May I just read that? In order to prove the contentions, they have produced the conveyance deeds, copy of the letter.
Extension order?
Not the extension order, page 232. Concept application. 232.
That is the original
interim order.
That is in the other. That is in the other
Yes,
appeal. But 232 has it, my lord. 232 has the parent order.
Yes. Mr. Shen placed from there only.
Yes.
Yes.
So all the deeds are referred to, and the last is what your lordship said, evidencing such long-standing use. The photographic records evidencing such long-standing.
How can the photographic record
Well, cannot evidence, but that is a conclusion which that is a conclusion which the court has drawn from the photographs.
Yes.
Pleading is there, my lord.
The lady in the photograph had been standing long, it appears from the photograph. She was looked very tired. But otherwise, there is nothing long standing there in that.
No, my lord, I don't want to say, but that is a conclusion the court has on seeing the photograph and keeping in mind that the construction is new, but adjacent construction is new.
Very.
So deeds raised as a whole with the photographs are what have weighed on the court, my lord.
Yes.
And my lord, your lordships can always, my lord, supplement the reasons, my lord. It's not that it's bereft of any reasons. The consideration is there. And these are the same what I've shown your lordship. In addition, I've shown your lordship the pleadings in the plea. Those are my
Right, just take.
Yes.
Just a few things, only thing which I want to emphasize is that whatever his, as it fell from your lordship, my lord, we will have to see his final deed of conveyance. Has he got what his vendor had got from the developer? Even assuming, my lord, that agreement for sale of his predecessor is incorporating everything in the conveyance of his predecessor, has the conveyance which he has got given him everything? And if a lordship just comes a few paragraphs of the conveyance,
Yes.
117, page 117.
Yes. 100%.
Kindly, sorry, 118. Last paragraph of 118 is where the reference is to the agreement for sale of Bahetis. Jointly agreed to, last three lines, jointly agreed to purchase and acquire a flat on the 9th floor. Then, my lord, 119. Kindly see this part, my lord. Together with proportionate share or interest in all common parts, portions, areas, and facilities, together with the undivided proportionate share in the land comprised in the premises attributable thereto, as more fully and particularly described in the second schedule hereunder written. And accordingly, an agreement for sale was signed, executed. So, refers to an agreement for sale of the Bahetis.
Mr. Shen, let us go to the places which more, were the best for them, according to us.
Yes, yes.
Please come to page 124, because so that you can answer on
Yes,
this.
124.
124, about 6 or 7 lines from the bottom.
Yes.
Together with the undivided
Yes, yes.
After
I was just coming to that, my lord.
So it just
the main
because
part
the
of the
previous part are the recitals, we
Yes.
are not on this.
So this is
This is the habit. So,
now kindly see what has been conveyed to him.
Yes.
Residential flat measuring such and such, 2 numbers car park,
You can start
together with
yes.
undivided proportionate share in the land comprised in the premises attributable thereto. So premises is described in the first schedule. Undivided proportionate share in the land more fully described in the second schedule. So second schedule is the unit which he has got out of the land described in the first schedule. Together with right to use and enjoy in common with owners and occupiers of other units and spaces at the building complex. The common parts, areas, facilities, amenities at the building complex, more fully described in the third schedule.
Yeah.
So this is his common area which he has got. And all manner of former and other rights, privileges, easement and benefits whatsoever belonging or in any way appertaining thereto, or usually held or enjoyed therewith, reputed to belong to, and the reversion or reversions.
So this part, former and other rights.
Now, kindly let us read together with easements, quasi-easements or other stipulations or provisions for. This is ultimately qualified by for beneficial use and enjoyment of the unit as mentioned in part 1 of the 5th schedule. So this entire thing has to be is qualified for beneficial use and enjoyment of the unit as described in part 1 of the 5th schedule.
But if the agreement for sale was made a part of this the vendor's deed,
of his vendor's deed,
yes, we are coming to this vendor's deed, then they were an inextricable part of that rights and privileges appertaining to his vendor's property.
Vendor's property.
He is being given that same thing in the sense that including former and other rights, privileges, easement appertaining thereto, including beneficial use and enjoyment of for beneficial enjoyment. So why shouldn't we read into this those appertainments?
No, then because they have now qualified that in part 1 of the 5th schedule. Whatever rights, former rights, easements and everything for beneficial use and enjoyment as mentioned. So I have limited it in your deed to part 1 of the 5th schedule. This is number 1. Then your lordship will see some other thing which I want to show. Same page, kindly see thereafter. And the owner's vendors covenant with the purchaser as follows. This is also very important. Because this is specific what his vendor is covenanting with him and giving him. Vendors have good title, absolute authority to grant, sale, assured the said unit. Hereby granted, sold, transferred, assigned and assured unto in favor of the purchaser free from all encumbrance. Purchaser shall make, so vendor is not covenanting with him to give him all his rights under that agreement for sale of 2009. Purchaser shall and may peaceably quietly enter into, hold, possess, enjoy the said unit, receive rent such and such, without any interference on behalf of by the vendors. Shall at all material times request and call produce or produce to him all direct, all deeds for evidencing title. Vendors, owners and vendor developer having lawful equitable interest whatsoever upon the said unit, hereby granted, sold, conveyed, transferred. And the owner's vendor shall and will from time to time hereafter request and cause to do execute, cause to be done, execute all such deeds for better enjoyment of the said unit. So this is all what 1 to 5 is what the owner is specifically giving him.
Yes.
Then here he is not incorporating his privileges under that 2009 agreement. Then kindly see purchasers from page 128. These are the purchaser's rights which he has acknowledging. Now, my lord, if your lordship comes to the first schedule once at page 131, this is the description of the entire property. 9832.34 square meter, 36B. Kindly see on the east there is KMC drain, which is the KMC road. So, my lord, this what my learned friend is saying, the physical existence of a motorable road within 36B. There is not a single mention also, my lord, in the first schedule. Therefore, the court cannot interpret or infer existence on the basis of an agreement of 2009 which is not incorporated by reference in his deed of conveyance, though it may have been incorporated in the deed of conveyance of his predecessor. Then your lordship will kindly see second schedule, and it mentions description of the property hereby conveyed. Vendor is conveying this part of the property out of 36B. Here, my lord, even if I come to the last 3 lines of this, together with proportionate share or interest in all common parts, portions, areas and facilities, and together. So first is common parts, portions, areas and facilities. Next part is together with undivided proportionate share in the land comprised in the said premises. What is one of this share in the land comprised in the premises? This is in the first schedule. So he has an undivided share in the first schedule land, which does not talk about a motorable road or common lawn or whatever. So even if your lordship takes the second schedule, somehow the vendor has not conveyed to him any lawn or motorable road or anything which is there in that 2009 agreement for sale. He has all the rights in the premises which is described in the first schedule. One can't add anything which is not there and described in the first schedule. And third schedule is very much.
Sorry.
Yes, sir.
Page 132, the end of second schedule, the language used is not comprised in the said premises and stops there. It's not that.
Attributable thereto.
And attributable there.
So what is attributable to the said premises is the first schedule description.
So aren't the rights which are given to his vendor also attributable to the premises by dint of incorporation of that agreement for sale, which in turn, which the terms of which were made a part of his vendor's deed?
It is part of the vendor's deed.
And which were a part which were attributable, those conferred rights attributable to those premises.
But my respectful submission, my lord, would be that the vendor, when he has covenanted on several express clauses in page 128, that has not been given. The rights which we were enjoying under the agreement for sale of 2009 has not expressly covenanted in page 120, because there are several clauses. Otherwise, generally, my lord, this clause would not have been there. And the purchaser to the end and intent, that is obligations, covenant, restrictions shall at all run with the said unit hereby covenant. When you are making specific provisions that the vendor is giving you all this also, the vendor is stopping short of giving the facilities and privileges under the 2009 agreement. And kindly consider this aspect of the 2009 agreement for sale, whatever is there, gives certain other additional privileges and facilities. Now, why shouldn't that be mentioned in the conveyance at all? And if my learned friend says that there exists a motorable road, all the more reason, my lord, that it should be part of the first schedule. When we are taking pains to describe the boundaries and also, my lord, third schedule facilities, not a single place we are mentioning, my lord, the motorable road. Because the only thing is, my lord, because this motorable road is on the east of this property where there was the KNC drain. That is the only reason. They could not in 2020 or even in 2009 deed, 2012 deed, mention about that motorable road.
What is transfer?
Now, my lord, with regard to the encroachment issue, my lord, kindly see what is my statement in para 25, which my learned friend has. Mark or para 25.
1, 2, 3 is only conveyed. Schedule it is not conveyed in the agreement.
Just 1 second, my lord.
It is conveyed in the agreement. Schedule 1, 2, 3. Schedule 8 that is not conveyed.
If your lordship kindly have a look at the agreement for sale once, which my learned friend had shown, 2009.
What is conveyed?
Page 167.
Document আছে এখানে.
Clause 3.1.
They have relied upon schedule 8, the recreation center.
In consideration of various amounts and subject to lordship has got it. Article 3, sale and transfer. Developer has agreed to sell and transfer all that unit number such and such at the said rate together to carpeting space and together with undivided proportionate share in the land comprised in the said premises attributable thereto, more fully and described in the second schedule, together with undivided proportionate share in the common parts,
Third schedule.
more fully described in the third schedule. So second and third has been agreed to be sold.
Not the 8th schedule. This much has been.
Kindly see now, my lord, the schedule. Yes. Second schedule is at, my lord, page 179. Same, my lord, same description as in here. And together with undivided proportionate share in the land comprised in the premises attributable thereto. Then third schedule is the common parts and portions. So, my lord, this is the same.
They have relied upon the 8th schedule. 7th schedule they have relied upon, which is
facilities. Now, the seventh schedule, which my learned friend relied upon, it is not part of his common area,
That's not part of conveyance. That is
or in the, it's not even in there in the conveyance.
salient subject matter, salient transfer.
So, my lord, sale and transfer subject matter is second and the third schedule of the agreement.
The seventh schedule relates back to clause 8.1 at page 174, Mr.
Yes,
Chair,
yes. That's common recreation.
That is, my lord,
which is a part of the.
What is transfer? 8.1.
yes, recreation center.
And then recreation center refers to 8.1 refers to the seventh schedule.
Yes, correct.
But this is not
Have
what
agreed
is
to provide some of the facilities which is to remain such and such
Not part of this. What is transfer?
of the said building. So they have agreed, the owner developer agreed to provide these facilities along with this whatever.
yes, my lord, whatever it is there, it is there. But now my
And then
case-
seventh schedule is connected and seventh schedule contains this whatever he placed.
this is my not that is my submission that this aspect is not transferred to him under the contract.
No, to his vendor it was transferred.
Maybe to his vendor has got it.
Once it was transferred, doesn't it become a part of the facilities which go along with it appertinent?
Well, I will have to specifically transfer it.
It is not transfer.
There is no implication for transfer.
If you have to hear it so much and interpret
No,
it
no.
so much,
No,
no. I mean, it may be our limitation also.
no,
we
but
are reading
that is
so.
not the thing.
But
but
not that in a general sense that if it has to be argued so much, isn't it a tribal issue?
Your lordship will
Go for trial.
on the last aspect of the encroachment part.
Hmm.
But the encroachment part, my lord, kindly sees that prima facie, whether you are the owner or not, you have a right or not, that has to come out from your conveyance. The first schedule, the second schedule, the third schedule of your conveyance.
Yes.
Not a single place it mentions about this motorable road, central lawn, anything. And this aspect of the matter has not been adverted to by the learned court below. My lord. Kindly see, and how can he get an injunction against the true owner? And I am not making any, there is no.
You are not claiming to be anyone in respect of the property.
My lord, the motorable road portion,
You are not the true owner.
that actually that belongs to me. That is a leasehold interest given to me by the KMC. That is what I'm trying to show your lordship from the first schedule. First schedule, admittedly, he describes that on the eastern portion there is a KMC drain. This KMC drain is the defunct drain for which there is a registered deed of lease
2009.
of 2009.
It was not there.
In 2006, that was
File
not
an
there.
objection and have it thrashed out. At this stage, we cannot look into your documents.
No, I am not saying that, but kindly have a look that order, my lord, on what basis is this order of injunction passed? That is only on my case, my lord. The in
1 second.
Yes.
More than 1 second actually.
Which is getting after to the proceeding. How I am reserving and the owners meters to the point.
Part 2.
The client number WhatsApp.
এটা হচ্ছে 8 ডিট
অনিল যে বলেছে
User convenience to এটাই তো মেজরই কনফারেন্স স্টাফ
এটা সেকেন্ড কনফারেন্স মানে ওট গেট ইট
2020 conference.
limited area ছবিতে দেখিয়েছে বলেছে 44,000 that is creating some sort of confusion.
কমন ইন্ডিয়াতে লাইট ভেন্ডারের রেখে কিন্তু সেটা একটু রেকগনাইজ করছি যে ওকে
পুরো যেটা corporate, এটা
Corporation document দেখাতে হবে, even if you don't.
Yes, please continue.
I just want only one, just to seek one clarification. If your lordship sees, the injunction is defendants are restrained from disturbing peaceful possession by the plaintiffs over the suit property.
Yes.
So, my lord, first, even if your lordship discards the question of conveyance interpretation, what is the document of evidence regarding possession of the plaintiff over this suit schedule? Number one, the suit schedule on a prima facie reading is contrary to the right given to him by the conveyance. Even if it is a question of interpretation, now if you are asking for an injunction, you must show undisputed document of possession. Only saying in the paragraph that I am in the unsettled possession for a long time is not an undisputed document. What is an undisputed document of possession? I will, for instance, for a particular property which is butted and bounded, I will show whether that there is a corporation tax bill, for there is an electricity bill. I am in possession. In any case of injunction restraining other side from coming into possession, I have to show my possession, unsettled possession. For unsettled possession, I will have to show at least one undisputed possessory document. What is the possessory document which he has shown to the court except some of these photographs? Photographs does not show his possession. What it shows, there is a motorable road. Motorable road is not corroborated from his conveyance deed. He asks the court to read to his conveyance deed, an earlier conveyance deed of his vendor, an agreement for sale of his vendor, which is not expressly mentioned in the conveyance deed. Let us forget about that part. But possession, he is getting an injunction over to protect his alleged possession. Where is that singular?
Now, Mr. Shen, you are re-arguing.
I'm sorry, my lord, but where an injunction is granted, your lordship will only look into his undisputed possessory document, which is not there with the court. Court has not referred to any possessory document. He could have got, but if the motorable road is within his property, a corporation document should have sufficed.
We'll hear Mr. Thakkar a minute on possessory document, because that was a new argument. And
Yes.
Mr. Shen, before parting with you, please come to page 136 once. This is
136 is the earlier deed.
yes. This is the no. This is the
2020.
Or 2020. Yes.
20 deed.
Yes.
Probably Mr. Thakkar's client's deed.
Yes. 130.
135.
Fifth schedule part.
Yes. Fifth schedule, my lord.
These are the rights reserved.
Yes.
Because yes. Please see one.
Purchaser will be entitled to all rights, privileges, vertical and lateral supports, easements, appendages, and appurtenances whatsoever belonging to or in any way appertaining to the said unit. Yes. And the properties appertinent thereto usually held, used, occupied, or enjoyed, or reputed to be known as part and parcel thereof, or appertaining thereto, which are herein more fully specified.
Then accepting and reserving unto the owners whatever
Vendors and the rights,
whatever follows.
easements, and further more fully described in part 2 of the 5th schedule.
Now, if you
So, my lord, kindly see paragraph 2 is to be read with paragraph 1, which are the rights which are fully specified.
now if you look at part 2, all of them tacitly admit the common rights of them, the purchasers, to whatever has been reserved, because all the entire part 2 is reservation of common rights in certain things for the vendors, their
Yes.
vendor.
Accepting and reserving unto the owner's vendors.
Yes.
And the rights even part 2. So these are rights which are not given to him.
So apart from these, everything else is given to him, whatever goes with the unit.
Or, my lord, yes, but those are also which are more fully specified.
This is on your argument that whatever his vendor had were not given to him.
Yes.
This is on that argument.
Yes, my lord.
Now, on that argument, it has been categorically mentioned that accepting and reserving whatever has been accepted and reserved, everything else goes with the property to him.
But whatever has been specified in paragraph 2.
All right.
which are herein more fully specified. So that is also curtailed by 2.
All right.
And 2 does not talk of anything else, of that motorable road and anything.
Motorable road is not specifically mentioned anywhere.
Anywhere.
That you are correct.
And
Motorable
even
road and this
lawn,
in
common-
that language at least it's not
there,
mentioned.
but not anywhere. So here also it could have been incorporated.
Yes. Could have been.
This is on the aspect of title, but if the injunction is granted to a third party on possession, then something on possession has to be there. And I have the sanction plan is also relied upon in the conveyance deed. So it forms a part of the conveyance deed. And the sanction plan negates existence of any motorable road, which my learned friend is justifying from the pictures. So that sanction plan could not have been totally ignored by the court below. It is just as his 2009 agreement is being incorporated in the conveyance deed, so is the sanction plan being incorporated in the conveyance deed. And even if I privately agree with him to give him something, if the sanction does not permit, my agreement becomes infructuous. A private arrangement is superseded by the final municipal sanction.
Yes, Mr. On possession, what is your argument?
My lord, the nature of the suit property is such that it cannot be in the exclusive possession of the plaintiff. That is prayer raised declaration that I have an undivided right in this property. The nature of the property is such.
Possession of plaintiff. So he's 36A. 36A, he has an undivided interest.
36A, he is 36.
I'm sorry, 36B. So getting confused. 36B.
Suit property is the passage in between, the motorable, so-called
Yes.
motorable.
So they are saying their building complex is in possession of that property, and therefore he has an undivided interest. So their 36B persons.
Please, let us hear him answer. Yes.
My lord, the nature of the suit property is such that is a road that it is not any. It is not. There is no
Physical possession as such cannot be shown.
Physical possession as such cannot be shown except for the fact that it is within my boundary walls.
Boundary wall and all.
Is there, and it is excluding. It is outside his boundary wall. The photograph shows it. His boundary wall is very clearly adjacent to the property. That short boundary wall. I hear murmurs.
Shed boundary wall. That's not a demarcation.
Right side.
It's completely
shed boundary wall is my boundary.
It is inside the property.
It's the short boundary wall within
this one, my lord, this one your lordship is seeing. This
page.
Right
Mr.
side.
Sen. Can you see page 222 for
So this is my building. This is 36
Is
A.
correct. And
So
can you
this
see the
is-
boundary?
No, that, yes.
This is a tin shed, my lord, complete tin shed boundary wall.
That is a brick.
No.
Photographs say that. The brick built wall will has brick pillars in between. That is the column.
That we will have to give evidence, but it is a tin.
Yes. This is the wall. Yes. This is by no stretch
No, my lord, this
a
is
tin wall.
It's 227. You have given this set to him, Mr. Thakkar?
yes, this one, your lordship is
It's 227.
Right hand side.
226 also.
this is completely tin shed, my lord.
226 or 7?
এটা দেখাচ্ছে তো?
We are showing you 227.
227.
We don't have the
227
page number.
But actually the page number is
Page
not-
is not there. Asha.
Page
numbers
number
are
is-
there.
I should see from here. 227.
My lord, I don't want to lead evidence from here, but whatever is the boundary wall, the road is outside the boundary wall.
Photograph was before the trial.
The road is outside the boundary wall.
This is tin shed, 227.
Right hand side it tin shed. Left
Both
hand side
sides,
is yours.
Both side inch.
Both side tin shed. my lord.
That's also tin shed.
Yes, yes.
Now, my lord, let us. I say, my lord,
Big wall. Cannot be.
I take it to be. My lord, I don't want to adduce. I don't want to be the commission.
Lordship can
But-
send someone and find out. It's a completely tin
But
shed.
even if it is tin shed, let us take his case again. The passage is still outside. Let's take his case again. I said to the highest, he has not come into the passage yet. He has not included it within his possession. He wants to now shift his tin shed. He wants to shift his tin shed. It is not in his possession today. Let us, I don't know why this tin shed or brick or whatever it is, but it is, passage is outside. And on all sides, kindly see on the on the other side also the passage is going. And not his case that he has built the passage.
Sanction plan.
He is not, the sanction,
If there are tin sheds either side, then whatever applies to him applies to you also.
that tin shed is bounding the lawn. That is a separation of
That's
the.
one side. The other
Yeah.
side, it
Is
is
the
not, we
lawn.
are now not sure about whether it
No.
continues as a tin shed or a.
So that is, my lord, on 227 your lordships are saying. 220, yes, that is 227. On the left is where the building is coming up.
You see that it continues further towards the far end. We
To
are
this
not
end.
sure now whether, yes, the left side. The
It
one
goes
which
to
you are-
this side. Or this side your lordship is talking of.
That side, your side,
My side, this side.
not that one.
This one.
Yes.
Yes.
You're pointing to something else.
Well, this is the photograph. The building is here.
You take it towards you,
Yes, please, my lord.
your left hand side.
My left hand
That
side.
wall.
It continues.
Not this side. We are saying far off, far away from you.
Yes,
Away
my-
from you.
Yes, my lord, away from me.
It appears to be. We are not sure whether it's a continuation of a brick wall. It may be a tin wall also. At the
Very
far
well, my
end.
lord. I leave it. I take it that it
Then
is.
both applies to you. You are also not in possession from the photographic evidence.
No, my lord, this. My lord, I'm not made myself clear.
Mr. Can you show him the
My lord, this
The
is his boundary wall.
tinness of the brick?
This is his boundary wall.
Show Mr. Thakkar what we are meaning and you are meaning.
Yes, this is the boundary wall.
Yes.
Now, my lord, this boundary wall does not cover the passage in question. The
No.
passage in question is outside the boundary wall. What is in his
Both
possession?
of your boundary walls, outside both of your
No,
boundaries.
no, the right hand side boundary wall is not the right hand side bound. That's what I was telling you.
The lawn tin shed.
This is
the
the
one
lawn
which is
tin
clearly
shed.
tin.
Yes. So that is the separating the lawn from the passage. That's why the central lawn and the passage are both part of. It is both are outside his boundary. Both are outside his boundary. The tin on the right at 227 separates it is to stop people from the road coming into the lawn. It's a division between the lawn and the boundary. That is 228.
But the sanction plan should be the answer, brother.
This-
They have constructed
There
a
can
building.
be
I am not yet constructed. So their
I don't
sanction
need to
plan is
address on a
satisfying.
sanction plan which is not there, but any violation that the corporation will take care of. Properties are sold, constructed and sold in violation of sanction plan. They're regularized, but there's nothing in violation here.
Closing arguments, this will never end. So, hearing is concluded. The matter is reserved for judgment.
Obliged.
এটা আমাকে
Obliged, my lord, for a
No.
very lengthy hearing.
Not at all.
Grateful.
It is stateful. No.
না দেখতে হবে কথা প্রশ্ন
5 years. Tomorrow, first half will be sitting in division bench. We'll continue till some time. We are just giving out in open court. If you know somebody else who has tribunal matters, we'll continue with these matters tomorrow. কালকে তো আমাদের ডিভিশন বেঞ্চ তো আছে সকাল থেকে এটাই রাখো এগুলি রাখো ট্রাইব্যুনাল অ্যাপ্লিকেশন টাচ হচ্ছে না ট্রাইব্যুনাল এগুলো ট্রাইব্যুনাল ফর হিয়ারিং
these matters probably my lord will face some predicament since the change of panel. The persons who are appearing on behalf of the states, they are not there anymore. My lord will probably have to direct service.
The new matters will be taken up.
I'll circulate in the meantime in the group.
No, don't circulate. তাহলে কি কালকে কি নেওয়ার কথা বলেছিলাম কোনটা নিলে ভালো কোনটা বেশি জমে গেছে কোনটা রিট অ্যাপ্লিকেশন ট্রাইব্যুনাল অ্যাপ্লিকেশন
construed as restoration of his possession on the allegation that he has been dispossessed. That order was also 19B was also allowed in his favor. Those two orders, as well as the similar orders passed in respect of a separate person who alleged claimed to be a Bargadar. Now, those are the four applications which were appearing. My lord, may I just place the order, my lord? After that, brief facts leading to these cases are, my lord will find that at page 46, paragraph 2, Devnaran De, who is the private respondent before your lordship, Devnaran De in CO number such and such filed an application before the revenue officer empowered under sections 50, 51, 21D of the Land Reforms Act for recording his name as Borgadar. The officer registered case number 16 of 1992 and ordered field inquiry to be made by the circle inspector. The circle inspector submitted his report. According to the petitioner, the copy of the application filed by the opposite party number 1 and the report submitted by the circle inspector were never supplied to him. The witnesses examined by the officer were not allowed to be cross-examined. By an order dated 3rd of October 1996, the officer came to a finding that the opposite party number 1, Devnarande, was a Bargadar in respect of certain plots of the land stated in that petition. A similar order was passed on an application filed by the opposite party number of Anil Kumar Hens. This is the other, who is not before your lordship. In both cases, the learned authority found that the opposite party number 1, Devnaran De and Anil Kumar Hans, were in cultivating possession of the respective plots up to 1991. In spite of the fact that the learned authority came to a positive finding that both the opposite parties were out of possession ever since 1991, yet he ordered the names to be recorded as Borgadar on the applications filed in 1992. He advised them to file applications under section 19B of the Land Reforms Act, challenging their forcible eviction from the respective plots. Accordingly, the opposite party number 1 in both cases filed an application under section 19B of the Land Reforms Act on 2nd of May 1995. Both the applications were allowed by identical orders by the competent officer in spite of the fact that the limitation for filing an application under section 19B of the Land Reforms Act was 2 years from the date of alleged dispossession. The petitioners filed an appeal against each of the 4 orders. Learned appellate authority, without going into the merits of the case, passed perfunctory orders and dismissed all the appeals and hence the said petitions. Now, my lord, may I, my lord, take my lords to those orders passed by in the first course of litigations. My lord will find that yes, my lord, we'll find the application at page 26, filed by the private respondent or before the authority. It says, গ্রাম নিবাসী শ্রী দেবনারায়ণ দে পিতা মৃত ভৃগনাথ দে এক ক্ষুদ্র ভাগচাষী আজ দীর্ঘদিন ধরিয়া বর্ধমান বহিলাপাড়া শহর নিবাসী মৃত প্রভাত চ্যাটার্জি মহাশয়ের পুত্র শ্রী শ্যামল চ্যাটার্জি মহাশয়ের গাংপুর মৌজাস্থিত দাগ ও খতিয়ান নম্বর অনুযায়ী নিম্নলিখিত সম্পত্তিগুলি আজ দীর্ঘ 10 থেকে 11 বছর যাবৎ ভাগচাষ করিয়া আসিতেছি, কিন্তু মহাশয় এমত অবস্থায় 10-11 বছর ভাগচাষ করা সম্পত্তিগুলি মালিক পক্ষ শ্রী শ্যামল কুমার চ্যাটার্জি মহাশয় বিক্রয় করিবার মনস্থির করিয়াছেন এবং আমাকে নিজস্ব সম্পত্তিগুলি হইতে ভাগচাষ উচ্ছেদ করিবার চেষ্টা চালাইতেছেন। অতএব মহাশয়ের সমীপে আমার প্রকাশ্য থাকে এই যে আমি একজন ক্ষুদ্র ভাগচাষী, ভূমিহীন, অশিক্ষিত, গরিব ব্যক্তি হিসেবে যাহাতে নিম্নলিখিত দাগা খতিয়ান নাম্বার গাংপুর মৌজাস্থিত শ্রী শ্যামল কুমার চ্যাটার্জি মহাশয়ের সম্পত্তি, this is with regard to his name to be recorded as the Borgadar in respect of the said property. I am the admitted owner who is the petitioner. Now, subsequently, they filed an application on 1992. My lord will find that on the next page. It's identical in nature, praying for protection of his possession. Now, the orders passed in the first round of litigation starts at page 29.
Let us see that application, that
Yes, my
relevant
lord.
portion of that application.
Yes, my lord. It's page 28.
Yes.
It's illegible in some parts, even in my brief, my lord. May I just read the second paragraph, which is the relevant portion? মানে উল্লিখিত ঘটনার বিবরণ হইল উক্ত প্রভাত চ্যাটার্জির কন্যার গাংপুর মৌজাস্থিত আন্দাজ 16 বিঘা সম্পত্তি আমি দীর্ঘ 10-11 বছর যাবৎ ভাগ চাষরত অবস্থায় ওই বছর মালিকপক্ষ চাষের জমির প্রভাবশালী ব্যক্তিকে বিক্রি করিব বলিয়া ও সাহায্য লইয়া আমার ভাগ চাষ হইতে উচ্ছেদ করিবার চেষ্টা করিলে জমিতে চাষ দিলে আমি ছুটে যাই এবং স্থানীয় গ্রাম সদস্য প্রধান সাহেবের নিকট আমার নামে ভাগ চাষি করিবার জন্য একটি দরখাস্ত করি। ওই দরখাস্ততে গ্রামের সদস্য এবং যাহাতে আমার নাম বর্গাদর রেকর্ডভুক্ত হয় তার জন্য this is with regard to his earlier application which he has filed, he refers here, which was already pending at that point in time.
The entire full application is not there.
No, and this full application is not part of the records, my lord.
Then
I'll-
this prayer portion is not there. I mean,
Well,
whatever is
this which was with regard to paper book. আচ্ছা, না?
we don't know whether this what was
No,
his
my lord.
prayer actually. Because your one of the premises of your argument is that his prayer was for protecting his possession. We don't find that from
No, my first argument ought to have been, my lord, whether he is at all entitled to be recorded as a Borgadar. After that, it comes to his protection or his
that is also
restoration.
protection. You are also arguing protection.
Yes,
we
my
have
lord,
to
I am.
find out his prayer at least. Here only one page is
Yes, 19, page number
annexed
28.
here. So how do you know even
No, Mr. Roy is, my lord, finding that document, my lord.
Mr. Roy and the paper?
As well as
Lordship, I'm just looking up the application under Article 226, but if it
Yes,
is
yes,
totally is there, I'm just looking.
yes, yes, please.
if my lord kindly now the next page, my lord, it starts the order of the revenue
This
officer.
is an informal paper book,
This is a
sort of index is.
sort of everything. No, this is file with regard to a writ
This is the
application.
writ application, right?
This is the original application.
So if it's not there, then where can you find?
না এটা নয়,
তাহলে কোনটা?
এইটা এটা নেই, কমপ্লিট নেই, উক্ত জমিতে 3 বলে শেষ। Now my lord kindly comes to the order starts at page 29. My lord, I'm not. My lord kindly comes to page 31.
Because this page 20, it ends with সমস্ত বর্গার কাজ করার পরেও মালিক শ্রী চ্যাটার্জি পুনরায় জোর করিয়া ট্রাক্টর দিয়ে উক্ত কিছু জমিতে then it's gone. So it might have been evicted also.
Might have been evicted. My lord, he admittedly filed his application for restoration in 1995, which is made part of the records and reflected in the orders passed by this honorable court as well as the orders passed
But
by.
in our order, we have to narrate the facts.
Yes, my lord, I'll just.
Anyway, let us see the order.
Yes, my lord. My lord kindly comes to page 31.
Hmm.
My lord, from the middle portion. 4, 5, 6, 7.
This is a composite order on both the applications.
My lord, this is
Yes, yes.
with regard to the first application of his recording of his name as Borgadar. It also, my lord, will find that there is a inquiry report of the revenue inspector received. 12th line from the top,
Where?
page 31.
31.
It says
Inquiry report, yes.
it is also appears that the field inquiry report of the concerned revenue inspector is received. Gone through the relevant parts of papers, including the field inquiry report, it appears from the deposition of the applicant and the available document that he had been cultivating the claimed plots for more than 10 years and delivering the share of produce usually to the landowners without any receipt. This is where I beg your lordship to draw some attention to this receipt. Now, my lord, even in subsequent portions, my lord, it declares him to be the Borgadar, my lord, on the basis of those documents. My lord, it also on the next page, second paragraph, it also appears, it starts with from the written deposition of the landowners that they engage the petitioner as a manager caretaker. This has all along been our stand. Of the cultivating of the suit plots, there was no agreement of this work. They have the lands under their personal cultivation, gone through the petition and local cultivators adjourned. Now subsequently, my lord kindly comes to this is that application my lord will file from page 34, which records order number 5 dated 18th of December 1992. Page 34.
No, page 33 it said the petitioner had been cultivating the claim plots.
Yes, my lord, this is with regard to his submissions, recording of his submissions.
Very well, yes.
Page,
Dated 5.
page
Order number 5.
order number 5. Both parties are present, had gone through the deposition of Devnara, son of Dev, Lakhon Chandra De, son of Devnarayan De, that they have been evicted forcibly again in the month of July this year. But this is where that application was filed. This is sum and substance, the prayer of that application which is
No,
missing.
they say forcibly again. When was the first time they were
Huh?
that got the other page?
Yes, I have got this application, Lordship. If your Lordship so desires, I will file it by a supplementary affidavit.
No, just you can hand over a photocopy.
He wants to record his name as a Bargadar in this application also. Yes.
Order number 10 is page 37, which is order passed in the first round of litigation.
You want to put it? You want to put it?
Without any no receipt.
Without any receipt for it?
No, he has also alleged that some political party members were put there, and in their presence, you had বহুজন লইয়া জোর করিয়া ধান রোপণ করে. So therefore, if you have shown that the crops there in that property, then Mr. Rai, he would have been dispossessed by that. It was in a sense dispossession. It's a cultivable land. জোর করিয়া ধান রোপণ করেন. If you have done that, then that amounts to your ousting him from position.
No, I am saying that I was appointed him as a manager to cultivate my land.
No, Mr. Mukherjee's other argument was
Yes.
that although he had applied for the second application was for protecting his possession,
Yes.
it was construed to be one for restoration of possession. It does not appear to be a protection of possession application. Rather,
An application, this is an application, if your Lordship will kindly see the prayer portion for recording his name as a Bargadar.
This is the second application. This is not that.
This is the first application.
No. First application was placed by him.
Okay.
In picture.
It was first application. The second application, there are copy.
Now, these two applications, the fate of these two applications, Lordship will kindly find. We have preferred a.
Mr. Justice, they is asking who is this Vittashali Prabhavshali Vyakti?
That I have to take instructions from my client.
You yourself heard that.
No. Yes. Now, he has filed an application for recording his name, thereafter restoration of possession. Now, your Lordship, both were decided in his favor, for which we have moved this honorable court. If your Lordship will kindly come to vegetable. Justice Tiwari's order.
Justice Tiwari's order complete করে না
Your Lordship has seen Justice Tiwari's order. Now, it was remanded back. Remanded back.
This is prior to remand. What was being?
Yes, yes. This is prior to remand.
first round of litigation.
Now, after remand, Lordship, again it was decided that he is a Bargadar. Against that, we preferred an appeal. Appeal court upheld that. Thereafter, the tribunal. The main question is that what are the criteria the court has to see, or the revenue officer has to see, whether he is a Bargadar or not. Lordship, my entire submission is based on one judgment, Lordship.
Cultivation and share of crops.
Cultivation, share of profit. If I am forcefully evicted, I have to file an application under 21D before the magistrate. Everything is there. If your Lordship, I'm placing the judgment first. Thereafter, I will show nothing to that effect has been decided by any of the, and it is his own admission. There is no receipt of bhakshas. If your Lordship will kindly see that in the order sheet, it was there. Page 31. No? 30. Yes, he has admitted, it is an admission, there is no bhakshas. Now your Lordship will, in page 30.
Yes.
No receipts is admitted.
Yes, yes. No receipt is admitted. If your lordship will kindly come straight away to page lordship 3,
Internal cost
internal page 3.
being agreed by the
Since the proceeding was remanded from that paragraph.
Yes.
Here also it was remanded. Since the proceeding was remanded with some observation following which is a said miscellaneous case was directed to be considered by the concerned block and land reforms officer, we feel it necessary to indicate in short the observations made by their lordship in their said remand order. It was held therein that the field enquiry which was relied upon by the concerned BL and LRO while passing the order prior to remand was a worse piece of evidence inasmuch as such evidence to such extent was hearsay evidence. Here also the same thing has happened. It is necessary in such a proceeding, but that does not mean that it would be not require subjective proof by derivative evidence. Their lordships held that in order to establish Borgadar in the land of another person, the Borgadar must prove the following: that he himself is cultivating land from his own sources. Second, that the sharecrops of the landowner in the proportion provided in the act, and such factum of sharing of crop must be established by documentary evidence, namely receipt. That in case of refusal to accept the sharecrops by the landowner, he must deposit the same to the credit of the landowner with the concerned BL block land and land reforms officer and obtain a receipt. That in case of refusal to grant receipt against tendering of sharecrops, the Borgadar has to lodge a complaint before the magistrate under section 19A 2A of the West Bengal Land Reforms Act. It was further held therein that lodging of that such complaint prima facie establishes the fact of refusal to grant receipt as section 19A 2A of the West Bengal Land Reforms Act provides that.
Mr. Rai, we'll have to rise a bit early today.
Lordship.
So we'll continue on the next day. Nowadays, we are not marking as part heard because we don't know when the bench, but we record something. Matter is heard substantially, Bishop. However, the same cannot be concluded today. So accordingly, let the matter retain its position in the list. Achha, na, it is specially fixed. Matter will be listed under the heading specially fixed matters on Thursday. Next Thursday, specially goes above the other.
Lordship.
Next Thursday, that is
This judgment has been affirmed by the Supreme Court also.
September 3, 2026.
Just now, my learned friend has told me that
SLP was dismissed.
SLP against this judgment.
So
SLP
if you get a copy of that,
yes, yes, sir.
Achha, after line affidavit of service fact to be kept. And also that other page of the missing page.
Yes,
That also please take out photocopies and